challengers and counsel for the challengers please state their names clearly for the record? We can start with the challenger closest to me and move. And please activate your mic. You can do that by pressing the signal where you can see. Yeah, perfect.
Mary Ann Royal.
Attorney Amy Dietrich for Citizens for Responsibility and Ethics in Washington, which is an intervener in this case.
My name is Paul Gordon. I am a citizen in Portland, Maine.
So, yeah, Miriam, yeah, thank you.
James Kilbreth, I'm attorney for petitioners Strimling, Saviello, and Rosen.
Benjamin Gaines, attorney for petitioners Strimling, Saviello, and Rosen.
Ethan Strimling, Portland.
Tom Saviello, Wilton.
Thank you. Would the counsel, would local counsel for Mr. Trump please state his name for the record?
Benjamin Hartwell.
For the record, I am accepting the pro hoc vice motion for additional participation by outside counsel for Mr. Trump. Would additional counsel for Mr. Trump please clearly state your names for the record?
Gary Lukowski, counsel for President Trump.
Scott Gessler on behalf of President Trump.
And would prospective interveners who have not yet identified themselves for the challenger please clearly state your name for the record?
Mike Sobolewski of Phillips, State Representative, District 73.
Thank you. I would also like to introduce Joanne Bautista, Deputy Secretary Policy Advisor. She is overseeing the admission of exhibits and will be tracking those for purposes of the hearing. She's also an attorney and may be advising me alongside Assistant Attorney General Jason Anton. We have received several intervention applications. And my understanding from the parties is there is no objections to those intervention applications. Without objection, there is?
Yes, and I apologize. I understand that there was an order issued asking for objections by 5 p.m. We do object to Crew's intervention in this instance for two reasons. One is the obviously short time notice, but the other is that by intervening on behalf of the challengers, I'm sorry, is it challengers or petitioners, the appropriate terminology? Your preference?
Challengers.
They're essentially submitting a challenge themselves. That's essentially what it is by challenging President Trump. And the deadline for those challenges was December 8th. And so additional challengers should not be allowed in this instance. If they want to obviously submit an amicus brief, that's a separate matter, or represent one of the challengers, that's a different matter as counsel. But intervening at this date along with a new witness is beyond the scope of the statute and prejudicial.
Does counsel for Crew have a response?
Yes, thank you, Secretary. Well, I think my first response would be that your office set forth a deadline and schedule for petitions to intervene to be filed, and Crew met those obligations. My second response would be that the petition that we have filed to intervene seeks only a limited intervention. We're not seeking to represent a party. We're not seeking to bring a challenge. It quite clearly states that we are only seeking a very limited intervention so that our witness, our organization, can authenticate certain exhibits. And so I think that with respect to the objection, it overstates, I think, a little bit what Crew is here to do today.
I'm going to call forward Emily Cook, who managed correspondence with the challengers, and to just approach. We have confirmed that correspondence was transmitted to the parties, informing them of a deadline for all objections to intervention. That deadline was 5 p.m. Thursday, yesterday. Because there is not a timely objection, without timely objection, I am granting the application to intervene filed by the Committee for Responsibility and Ethics in Washington for the limited purpose of filing a brief and accompanying affidavit. Without objection, I am also granting the application to intervene filed by Professor Mark A. Graber, who intervened for the sole purpose of filing an amicus brief. That amicus brief is accepted. Without objection, I am granting the application to intervene filed by Representative Mike Sobolewski in support of Mr. Trump. I'm denying the intervention application of Michael Lake because he is not present at today's hearing, unless Mr. Lake would like to identify himself, but he informed us he would not be present, and that was a condition of intervention. I am also denying John Fitzgerald's application to intervene because he is not present at today's hearing, unless Mr. Fitzgerald is present. See, because he is not, that intervention request is denied. Any witnesses who are participating today will be called upon at the appropriate time and asked to state their name for the record. The witness will then be sworn in by me. Do the parties at this time expect to call any other witnesses other than Professor Maglioka? Okay, seeing none, that will be the sole witness. This hearing is being conducted in person, but one witness is appearing by Zoom, and when that witness is called, I will call him forward in the same manner as witnesses attending in person. He will not be promoted online as an attendee of the webinar until he is called as a witness, but has the capability of observing the proceedings online. If any parties plan to offer written evidence, it should be described for the record and then handed to me to be marked as an exhibit, and each exhibit must be shown to the opposing party or parties and their legal counsel. Now, I understand that evidence from the challengers is still being downloaded on a drive and is being transferred at this very moment to the counsel for Mr. Trump. Evidence will be admitted if it is the kind of evidence upon which reasonable persons are accompanied to rely on in the conduct of serious affairs. I may exclude irrelevant or unduly repetitious evidence or testimony. I may also place limits on the parties' presentations as necessary today to prevent unreasonable delay. I ask that all parties, including interveners, keep their presentations concise and focused on the issues to be addressed at this hearing. The order of the proceedings today will be as follows. First, each challenger or set of challengers, as well as counsel for Mr. Trump, will be permitted an opening statement. Opening statements are just a brief summary of the argument. The more detailed statements will happen in the evidentiary portion of the hearing. I will then hear oral argument from the parties on the threshold legal question of the scope of my authority, a question I ask the parties to be prepared to discuss today. I may have questions for counsel on this issue after hearing their arguments. We will then accept any exhibits into evidence that are being offered without objection. The challengers, beginning with Ms. Royal, then counsel for Rosen, Saviello, and Strimling, then Attorney Gordon, will present their evidence and may call any relevant witnesses to support the challenge they have brought under Maine law, Title 21A, Section 337. Then counsel for the candidate will have the opportunity to cross-examine each witness, and Representative Sobolewski, as an intervener, will also be afforded limited additional time for cross-examination if he would like it. I may also have questions for the witnesses. Counsel for Mr. Trump will then present evidence rebutting the challenges and may call any relevant witnesses. The challengers will then each have an opportunity to cross-examine each of Mr. Trump's witnesses, and I may have questions for witnesses. It seems that there may not be any witnesses. Representative Sobolewski may then make his presentation. Because of the volume of evidence, the number of parties, and the limited time available to adjudicate this matter, his presentation will be limited to 30 minutes. All parties will then have an opportunity to make short closing statements, which will include any legal arguments they wish to make. By statute, Title 21A, Section 337, 2B, the challengers have the burden of providing sufficient evidence to invalidate the petition. The agency record at the start of this hearing includes the original petition of the candidate consent dated October 20th, 2023, the challenge of Marianne Royal dated December 6th, 2023, the challenge of Kimberly Rosen, Thomas Saviello, and Ethan Strimling dated December 8th, 2023, the challenge of Paul Gordon dated December 8th, 2023, and the hearing notice emailed to the challengers and the candidate dated December 11th, 2023. Does any party have any questions or objections to the procedure that I've outlined? Hearing none? Yes?
Just one question, Madam Secretary. For the threshold with respect to the scope of authority, we have two bases. One focuses on Maine law and the procedural issues here. The second, I sort of put in a category, encompasses the nature of the 14th Amendment, Section 3 itself. Do you want us to address both of those in the second element of the presentation?
In that portion of the hearing, we are most interested in the threshold question of the applicability of the Maine law. You may add additional arguments, but the evidentiary portion of the hearing is dedicated to the supposition put forth by the challengers that there is a violation of the constitutional threshold question. So that is a second. We expect arguments on that piece to be in the second part of the hearing. But in terms of my authority, you're willing to introduce any arguments that you like when we're having that initial conversation.
Okay, thank you.
Thank you. Are there any other questions about or objections to the procedure outlined? The parties may now be heard on the allegation that Mr. Trump is not qualified for office under 1, Section 3 of the 14th Amendment, and 2, Section 1 of the 22nd Amendment, such that the information contained on his candidate's consent form is false and his petition is invalid under Title 21A, Section 336, subsection 3. Do the parties agree that this is a complete and accurate statement of the challenges?
Yes, sir. Madam Secretary.
Ms. Royal, do you have an opening statement that you would like to make?
I do not.
Okay. Attorney Gordon, do you have an opening statement that you would like to make?
I do not.
Attorney Gaines or Kilbreth, you may now proceed with your brief opening statement.
Just briefly, Madam Secretary, I think we've laid out,
So, counsel, we're going to ask that you stand at the podium when you're making your opening statements. Thank you.
good morning, Madam Secretary, Mr. Anton, members of the bar representing the parties. My name is James Kilbreth. I'll briefly just restate the basis of our challenge. As we laid out in the challenge, we believe former President Trump on January 6th engaged in an insurrection against the Constitution of the United States. And under Section 3 of the 14th Amendment, that disqualifies him from holding the office of the presidency. The only challenge that can be brought to his eligibility for office under state law is now to his eligibility to appear on the primary ballot. That's the basis on which we filed the petition. We intend to introduce overwhelming evidence about, first, the insurrection, second, former President Trump's engaging in the insurrection, the meaning of the term office and the term officer under Section 3 of the 14th Amendment, and the fact that the state is the entity charged with enforcing Section 3 of the 14th Amendment. All that will develop through documentary evidence and the testimony of Professor Magliocca. Thank you.
Thank you, counsel for Mr. Trump. You may proceed with your brief opening statement.
Thank you. Madam Secretary, how do you prefer to be referred to?
Madam Secretary is appropriate. Thank you.
Having been a secretary, that's my normal MO for addressing people. So Madam Secretary, we'll make our opening statement equally brief. Let me begin by saying we do not believe that this tribunal, that this office has any jurisdiction here in this instance. Maine law is pretty straightforward in that it is limited to an attestation of the truthfulness of the Article 2 qualifications, and that's what President Trump has done, and that's appropriate. What the challengers are asking you to do is something that no secretary in the country, no election official has done. Everyone has declined to do that. New Hampshire, Michigan, Colorado, Oregon, Georgia, all of whom have been asked to engage in this type of in a disqualification, and every administrative official has declined to do that for good reason. Likewise, every court that has considered this issue has also declined to bar President Trump, including the state of Colorado, from whence I hail. And there's the good reason for all of that. States do not have jurisdiction. State election codes do not authorize the specific states, similar to Maine, do not authorize barring President Trump under Section 3 of the 14th Amendment. There's substantial federal jurisdictional issues that prohibit a state from engaging in this type of behavior. And under the text of Section 3 itself, it does not apply to President Trump, as was in fact recently decided in Colorado. In addition, the evidence here we think is improper. We've not had truly an opportunity to confront it, so we'll be objecting to that as well. And indeed, since some of that evidence and that proceeding took place, a number of people and others have come forward, and with the timeframes, we've just been unable to actually prepare and present that. So we think it's inappropriate for this for your agency to simply try and import another proceeding. It's unprecedented in my experience as well. We'll limit our comments to that. I would also note that Professor Magliocca, as a witness, he's also submitted an amicus brief, and it seems as though he'll simply be testifying to his legal analysis, which is not evidence and certainly is not directed to any of the factual findings under the Maine code as well. With your permission, as we present, may we have different attorneys come up for different sections of our argument?
Yes, certainly.
All right. Thank you very much.
And so may the challengers.
Okay. Thank you very much. We'll keep this brief. Thank you very much.
Thank you. Now, before the parties begin their presentations, I want to address the threshold legal question of the scope of my authority. Attorneys Gaines and Kilbreth, please proceed with your argument regarding the scope of the Secretary's authority to decide this question.
Madam Secretary, first, let me apologize. I'm going to remove my glasses because I need progressive lenses and they haven't arrived yet. The Secretary has clear authority under Section 336 and 337 to review the oath that the, excuse me, to review the declaration that the candidates made. Section 337 is clearly made applicable to Section 336 declaration within Section 336. Furthermore, Section 443, I'm sorry. Section 443 states that the Secretary shall prepare ballots for a presidential primary election. A ballot must include the name of a person who files a petition with the Secretary of State in accordance with Section 442. The Secretary shall determine if a petition meets the requirements of Section 335, 336, and 442, subject to challenge and appeal under Section 337. So that makes clear that not only is the truthfulness of the declaration that's made subject to the challenge, but the determination that the petition meets the requirements under Section 336. As to the Secretary's general authority to consider substantive legal issues within the scope of both the Section 336 challenge brought under Section 337, the legislature clearly delegated the authority to the Secretary to evaluate the qualifications of the candidates for various offices, legislative offices and federal offices, and directly under Section 443 makes that review authority applicable to the president. The only qualifications that are applicable to the president are constitutional. Within that review of constitutional qualifications, there will be, from time to time, substantive questions that arise. For instance, the secretary on her form lists the qualification of natural-born citizens. Well, there are questions that arise as to whether an individual is, in fact, a natural-born citizen. I can refer the secretary to the Pennsylvania challenge of Senator Ted Cruz in 2016. I'm sorry, I don't have the site in front of me, but I'm happy to get that to you. That argued that because Senator Ted Cruz had been born in Canada, he was not a natural-born citizen. There could be other substantive challenges under that constitutional provision that arise. It is necessary for the secretary, in order to evaluate the qualifications of federal candidates, to look to the Constitution and decide what those qualifications are. This issue presents some perhaps particularly difficult constitutional questions, some perhaps novel constitutional questions. But the scope of the secretary's authority to answer that question doesn't revolve on whether or not the questions are hard.
I have a series of questions that I may be asking multiple attorneys. Is it your position that I have the authority, if the qualifications at issue are not those listed on the candidate consent form? And if they are not, additionally, if they're not set forth in Maine statutes or in the Maine Constitution?
Well, I'll address that separately. The list that appears on the form is not intended to be operative at all. The legislative history in the 2011 bill clearly showed what happened was a legislator had someone qualify as a replacement candidate who lived outside of that district. The legislator proposed a bill that would have required the secretary to affirmatively verify the qualifications of every candidate for the legislature every year. The Secretary of State then said that that would be tremendously burdensome. They cannot do that, and suggested that an easy way to better inform the candidates for legislature of what their qualifications were would be to simply print a list on the form. So the provision that's in 336 sub 2 adds the requirement that the secretary print a list. That list does not make any authoritative determinations. And under Section 336 sub 3, there is no tying back in the oath that the candidates make to the contents of that list. Now, I am aware that the language on the actual oath that the secretary put on the form this year first is ambiguous. It could be construed in a number of different ways. It could be construed to, as listed above, could be construed to apply to the office that's being sought, as the form clearly requires the candidate to state the office being sought above on the form. And the previous word to that is office. The office the candidate seeks as provided above. It could be construed that way. It could be construed as some kind of informative parenthetical that simply informs the candidate of what the qualifications are, but doesn't in any way limit the scope of that oath beyond what the oath is supposed to say under the statute. But what is clear on 336 is that the actual oath requires a statement that the candidate meets the qualifications of the office the candidate seeks. So the secretary must, if there are alternative constructions that would allow that oath to meet the statutory requirement, prefer those constructions to one that would essentially void this oath and require the secretary to, under Section 443, determine that it does not meet the requirements of Section 336. However, as we just stated, because it can be construed to apply to those last words can be construed to apply to the office rather than the qualifications, the secretary should so construe the oath.
How about if those qualifications aren't set forth in Maine statute or in the Maine Constitution?
The legislature clearly set forth a duty for the secretary to make a determination of what those qualifications are. They're not specified in the statute. And I mean, the secretary has the authority under, well, I'm sorry, the legislature has the authority under Article 2 to state the manner in which the selection of electors is conducted. And that includes setting forth the procedures for qualifying for the ballot, even at the primary process. The state has the authority to keep unqualified candidates off the ballot. In the 10th Circuit, in the 10th Circuit, there's the Hassan case, Hassan 495 Federal Appendix 947, and these are both cited in Challenger's challenge first brief. And the second case is U versus San Francisco County Democratic Central Committee. I'm sorry, that's the wrong case. That's a note. Anyway, it's in the same footnote that the Hassan case is footnoted. There's a Ninth Circuit case that says something similar to the Ninth Circuit case is the case where a 27-year-old woman tried to qualify for the presidential ballot, and California kept her off the ballot. And the Ninth Circuit said, yes, California has the authority to keep unqualified candidates off the ballot. This is constitutional. So the legislature clearly has that authority to set that out in statute. And the legislature here has very clearly said that the secretary is supposed to make the determination of whether, well, subject to a challenge. Prior to a challenge, the secretary is not under Section 337 permitted to look beyond the four corners of the consent form. But upon a challenge, the secretary is supposed to review the evidence and the arguments that the challengers have put before her and make a determination as to whether or not there is a qualification or the candidate is not qualified for the office they seek.
Is it appropriate for me to adjudicate a complex constitutional question like that posed by Section 3 of the 14th Amendment as part of an administrative hearing under Section 337?
Is it appropriate? I want to try to divorce the policy question that's part of that from the constitutional question. It is constitutional, subject to procedural due process protections. And if I may, as an aside, the Office of Secretary regularly grants continuances in these proceedings. In 2018, I believe there was a request for a continuance in the Max Lynn case. There was a continuance in 2016, I believe. And the timing also only requires the secretary to return an opinion within 5 days of the closing of the hearing. I believe that a continuance would keep the hearing open and not run those 5 days until we reconvene. President Trump hasn't requested a continuance. So I do want to address kind of the procedural due process concerns that this procedure, right? But yes, if the secretary wanted to put a bill before the legislature and make a change to the procedures, they could be improved. And we would go testify at the legislature and say, these procedures are not adequate to complex challenges, not legally inadequate, but from a policy standpoint, these are less than ideal procedures. And we would support that change. But the law that the legislature has put before you is constitutional and constitutionally adequate to decide these questions.
Where does my authority come from?
Your authority comes from the legislature.
Okay. Section 3036, sub 3 requires a consent to contain a declaration of the candidate's place of residence and party designation, as well as a statement that the candidate meets the qualification of the office the candidate seeks. Is there any difference between the declaration and the statement?
No, there isn't. That's a good question. The legislative history on that makes it clear. I don't have that in front of me, but the legislative history from when that was put in, it was, I think, 1985, makes it clear that this was a secretary's bill, and the secretary was using declaration and statement interchangeably. Furthermore, it's superfluous language if it's not. There's no point to that oath if that's not part of the declaration. And also the secretary's practice has been to treat it as part of the declaration. So
should a distinction be identified? Does it affect my authority in this matter?
No, we don't believe that it affects your authority. At worst, the provision is ambiguous, and I think the purpose of the statute and the legislative history confirms that is the statement and declaration there are used synonymously.
If I don't have the authority to invalidate a petition for the reasons stated in the challenges under Section 336, is there any other source of authority under which I could do so?
Yes, challenges are pointed to Section 443. and 443 specifically, with respect to a presidential primary petition, gives the secretary authority to determine if a petition meets the requirements of Section 336, subject to challenge and appeal under Section 337. So that's somewhat different from the authority to determine whether a declaration is found to be false by the Secretary of the State under Section 336 sub 3.
Is there anything else that you would like to say about the threshold of my authority in this matter?
No, I think we've covered it. Thank you.
Counsel for Mr. Trump, you may respond regarding the scope of my authority.
Thank you very much. I may pop my glasses off and on as well. So, Madam Secretary, the argument from the challengers began with a statement that let me see if I can quote it, that the Secretary of State has clear authority. And I'd respectfully submit that when an advocate uses the word clear, it's normally a linguistic emphasis used to compensate for weakness in the logic or authority. And that's the case here. Attorneys do it all the time. They'll say this is clear, when in fact, it's usually the opposite. It's not clear. I'm going to defer some of the textual analysis of 336 and 337 to my colleague, Mr. Lukowski. I'd like to make a few points here. First, under Arsenal versus Secretary of State, and that's 2006 Maine 111, in paragraph 23, the Maine Supreme Court very specifically said that if the Secretary of State doesn't have explicit authority to add a restriction in law, it may not do so. And that was a case in which the Secretary of State's actions were challenged in a vacancy. And basically, the Secretary of State had created a procedure or requirement. And what the court said was, given the fundamental importance of the right to vote and the right to participate in the political process, and given the painstaking detail of the election statutes, if the legislature had intended to delegate to the Secretary the authority to add restrictions to this process, it would have done so explicitly. So the very framework with which we need to approach this is that absent explicit authority, an election official, such as yourself, does not have jurisdiction to engage in adding additional restrictions here. 336 does not allow that. There's a very specific form and requirements that your office has promulgated. And if the if the challengers believe that form is incorrect, the proper approach is to file a lawsuit to change the form, or to seek to challenge, ask for rulemaking authority, ask for a rule to be changed, allowing appropriate comment and reflection on this. Not a last-minute election change of the form to change the rules in midstream. That's inappropriate here. As I had said before, the general framework across the nation is that secretaries are allowed to execute specifically delegated duties. And no Secretary of State in the country has found a specific delegated duty under Section to enforce disqualification of Section 3 of the 14th Amendment. Now, the challengers talk about qualifications, and that this is a qualification, and the Secretary can can adjudicate qualifications. This is not a qualification. And in fact, on page 4 of their submission, the Rosen and Strimling challengers specifically said that Section 3, I'll refer to the 14th Amendment, Section 3 for shorthand, is not a qualification. It's a disqualification. Now, why does that matter? Under Article 2 of the U.S. Constitution, it basically says that no person except a natural-born citizen or citizen of the United States at the time of the adoption of the Constitution shall be eligible to the office of the president. Neither shall any person be eligible to that office who shall not have attained the age of 35 years and been a resident for 14 years. So Article 2 specifically talks about eligibility. That's why we talk about it as a qualification. If you look at Section 3 of the 14th Amendment, it says no person shall be a senator, representative, presidential elector, or hold any office under the United States. Their attempt is to bootstrap the president under office, the presidency under office of the United States. That talks about holding. So it's much different language. And we need to presume, and I think it's correct, that the drafters of the 14th Amendment were very careful. There was substantial debate in their word choice. They were careful in their word choice. And they did not cast this as an eligibility or a qualification. And the challengers admit that this is not a qualification in their written briefing. They say it is a disqualification. They are correct that it's a disqualification. But when they stand up here and argue that it's a qualification, they are incorrect in doing that. And so Article 2 qualifications are fundamentally different than a disqualification under Section 3. I would also note that your office and no office across the country has ever viewed Section 3 as a qualification. The petitioners rely on a district court case out of the 10th Circuit, the Hassan case. The full name of that was Hassan versus Gessler. Yeah, that was me. And that was a Article 2 qualification case. And actually what happened in that case was that the Mr. Hassan sought to run for president. The secretary promulgated a form, Article 2 form, and Mr. Hassan could not meet that. And so he chose not to fill out the paperwork. And he was disqualified to run for president, not because of a factual finding that he didn't meet the Article 2 qualifications. He was disqualified to run for president because he refused to submit the form. That's why he would have committed perjury had he submitted that form. And so that was the basis for removal, that he didn't meet those procedural requirements. And I would urge this court to basically look at Maine's neighbor. I'm here from Colorado telling Maine to look at its neighbor, but in New Hampshire, there was an exactly similar case. It was Hassan versus the Secretary of State of New Hampshire. And the Secretary of State of New Hampshire refused to allow Mr. Hassan access to the ballot because he refused to fill out the paperwork. So that was the same cycle, same year, same litigant. I would note that in this cycle in New Hampshire, the Secretary of State has declined to enter into a challenge or declined to adjudicate or declined to bar, however one wants to characterize it, declined to bar President Trump from the ballot under Section 3. So that's an instance where the Secretary of State of New Hampshire faced those exact Article 2 issues, refused to qualify, faces the exact same Section 3 issues here, and has refused to take action through a lack of authority. And that was based on advice from the Attorney General, and we're happy to provide a notice of supplemental authority. I don't think it's properly viewed as evidence, but rather as a supplemental authority. We're happy to provide that if you so desire. So that's an instance where a secretary has been confronted with this issue and chosen not to take action. I would note that there was a lawsuit against that, and that failed in federal court for lack of standing. With respect to this procedure, no, we don't think it's appropriate to adjudicate on this. In Colorado, it was not a full and fair opportunity to adjudicate it there either. And that was a 5 to 6 week ramp up period for a 5-day factual hearing. And that was not a full and fair adjudication, which I think in part is why the court chose not to rely upon that and rested her decision on a textual analysis of Section 3, which I'll get to that in a moment. I would note that everything in that Colorado case is currently being considered by the Colorado Supreme Court. We anticipate a decision soon. But in this particular proceeding, local counsel entered an appearance 2 days ago. Having learned of this, we entered an appearance yesterday. That is not adequate time to prepare to contend with, I think it's around 80 some exhibits, several of which we've not even seen and are completely unfamiliar with at this point. The Maine statutes contemplate, I would submit, a very limited factual finding, a very limited process. That's why it's a compressed time frame. Because what the purpose is to determine whether or not there's a violation of 336, which is basically whether or not a candidate has submitted the adequate number of signatures, which is not at issue here, and whether a candidate has truthfully attested to the requirements promulgated by the Secretary of State here. That's a very limited factual hearing. It does not contemplate 80 some exhibits. It does not contemplate litigation, adjudication of complex federal constitutional issues in the course of 5 days notice. It does not contemplate the adjudication of those complex federal issues when there's no ability to compel witnesses for events that happen 1,000 miles away. There's very, very limited opportunity to generate rebuttal evidence, particularly when it's very difficult to even see what that evidence is before us until the eve of a hearing. So we do and will formally state that to go forward on this or to adjudicate in the challenger's favor would be a fundamental due process violation here under the 14th Amendment, because the process due is wholly inadequate for the adjudication of these complex factual and constitutional issues, all of which are, frankly, issues of first impression here. Ultimately, this tribunal is limited to what is in the Maine statutes. But I would note a couple things, and I'll likely develop these later, but I want to at least bookmark them now. If you look at the actual text of Section 3, this tribunal, this administrative agency, does not have jurisdiction. Let's start with the Colorado District Court that looked at that. So basically, if you look at the language of Section 3, it basically says no person shall be a senator or representative in Congress or elector of president and vice president. So it names those 3 offices or hold any office under the United States. So usually the question is an office under the United States. And I understand Professor Maglioka submitted an amicus brief and Professor Graber has. We've submitted 2, I think, as exhibits to amicus briefs from a prior proceeding. There's a lot more legal analysis than just that, I will tell you. But the presidency is not an officer under the United States. When you look at how that is used throughout the U.S. Constitution and historically, office under the United States, and I'm not talking office in general, but very specific language of office under the United States in the federal Constitution in Section 3 does not include the presidency. If you look at the language of Section 3, it excludes the most important office, the presidency. It is not included, and that is consistent with the structure. The second is officer of the United States. So if you look at the language of Section 3, first, no person may hold an office. We're talking about the presidency, office under the United States. Okay, that person has to also previously have taken an oath as a member of Congress or as an officer of the United States, or as a member of any state legislature, or as an executive or judicial officer of any state. So 2 more elements. They have to take an oath as an officer of the United States. We have presidency as an office under. I emphasize this because it gets a little confusing sometimes. Office under the United States. an officer of the United States. The presidency is not an officer of the United States. That's very clear when you look at the structure of the federal constitution. Officer of the United States is used in 4 instances. And for example, under the Constitution, the president appoints officers of the United States, and he doesn't appoint himself. So if you look at the appointments clause, the impeachment clause, commissions clause, and the oath or affirmation under Article 6, they all use the phrase officer of the United States. And in every instance, they use that in a manner that excludes the president. The next element is the oath has to be taken to support the Constitution. There's 2 different oaths in the U.S. Constitution. One is an oath by the president, which is to protect and defend the Constitution. And the other oath is by everyone else, which is to support the Constitution. And that makes sense because the presidency is the apex office. The president is the apex officer of the United States. And every other officer is in a supportive position. So they take an oath to support. And the drafters of Section 3, this is in the 1860s, had a choice to make. And I submit back then oaths were probably a lot more important than they are now to our modern sensibilities. Certainly with perjury, we look at whether or not a person's taken an oath. But normally, at least in modern usage, we don't place as much of an emphasis on an oath of office. But certainly in the 1700s, when the original Constitution was drafted, and the 1860s, when Section 3 was drafted, an oath was a big deal. And that's why, in order for Section 3 to even apply, the person has to have taken an oath. So, for example, if there were a Confederate general who had fought against the Union, and that person had not taken an oath, Section 3 wouldn't even apply. So you have to have the oath. That was very important back then. And the framers, the drafters of Section 3 had a choice to make. And they said, what oath are we going to require? And so if you look at the organic Constitution, you have the Article 2 oath for the presidency, and you have the Article 6 oath for everyone else. And the drafters chose the Article 6 oath. And that is consistent with the usage of office under the United States, officer of the United States. And so by its terms, and there's lots more argument I can provide on this, and I may as necessary, but under its terms, Section 3 does not apply to the presidency, the office of the presidency. And in fact, it doesn't apply to President Trump because he was not an officer of the United States, nor did he ever take an oath to support the Constitution. He took a different oath by the terms as he was required to by the U.S. Constitution. He took the Article 2 oath. And that's ultimately what the Colorado District Court relied on. Now, the Colorado District Court provided lots of opinions, which are dicta and essentially are not binding, did not rest the decision on any of that evidence or analysis, but rested and did not rely on that at all, but instead relied upon a textual analysis. So this office does not have authority, just as no court has authority, because it does not linguistically, textually, analytically, Section 3 does not apply in this case. Let me talk about just a few other things. There was substantial debate at the time of the passage of Section 3. And during that debate, in particular, Representative Thaddeus Stevens, who's considered the father of the 14th Amendment, talked about how Section 3 was not self-executing. In other words, it required an act of Congress.
So I just do and invite you to present any and all arguments that you choose, but this portion of the hearing is specific to the authority of the Secretary of State of Maine for purposes of this hearing. The evidentiary proceeding, there will be substantial time for argument about the substance and nature of the allegation as to whether Mr. Trump did or did not violate Section 3 of the 14th Amendment. So please absolutely share what you choose, but this portion of the argument is specific to the authority of the Secretary of State of Maine. Okay.
I certainly appreciate that. I'll be brief, but I would submit that this does directly answer that question. So we're not talking about whether or not factually there was engagement in insurrection. And I'm not talking factually about any of the facts as to what happened on January 6th. What I'm specifically talking about is authority. I would submit that the challengers here have argued that you have authority to enforce Section 3, the disqualification of Section 3. And one of our responses is that you don't, because Section 3 simply does not apply. So there is no jurisdiction under the terms of Section 3 itself. So that's the point I'm seeking to make. So there's 2 forms of jurisdiction. One basis of jurisdiction would certainly be what the Maine legislature authorized. But the other form of jurisdiction is what the U.S. Constitution authorizes. So, for example, if the state of Maine said no one can run for president unless they're a minimum of 45 years old, that would give you authority under the Maine legislature, from the Maine legislature. But that would be prohibited under the U.S. Constitution because it would be an additional qualification beyond what the Article 2 qualifications are. So you would not have jurisdiction to enforce that. That's a similar analogy to what I'm arguing with respect to Section 3. But I will be brief, and I understand, and then we'll get specifically to the language of Section 336. Section 3 requires enabling legislation from Congress. That's what we generally term as sort of self-execute. Requires enabling legislation because Section 3 itself does not sort of come like a bolt of lightning. It requires standards, it requires procedures, and Congress is sent to do that. That was central to the debates, and I referenced Thaddeus Stevens, but also note that very early on, Supreme Court Chief Justice Salmon Chase, riding circuit, made a decision in which he said that Section 3 had to be self-executing. Now, there are some who have criticized that decision as inappropriate, but the fact of the matter, it was a decision and it was followed and it has been considered settled law. And the Griffin's case has been approved, I think, as recently as 1978 by a federal circuit court. Right after he made that decision, Congress then enacted enabling legislation. So there used to be legislation, no longer exists, specifically setting forth a quo warranto proceeding in which federal prosecutors could remove state officials and a federal official, although I don't think it was used in that instance, but they could remove people from office for violation of Section 3. So Congress specifically enacted procedures to do that. That was removed from the federal code in the 1940s, and I think the last actual prosecution occurred in the 1920s because Section 3 was designed to focus on Confederates, and I think by that time they'd pretty much all passed away at those late hours. But in order for this court, for this tribunal, for any court to be able to engage in that action, to adjudicate a Section 3, it requires enabling legislation from Congress. Every court in the country that's been squarely confronted with that issue and has decided it has agreed with this position, except for the district court in Denver. And of course, that issue is on appeal right now before the Colorado Supreme Court. So this court, this tribunal, this agency, doesn't have authority because it requires congressional action. And in fact, Congress has, in 2 instances, passed laws. It allows the president to declare an insurrection. And it also creates a criminal statute. It's called the Insurrection Act, in which if someone incites or engages, and we'll talk about that later, but incites or engages in insurrection or other activities, then that person can be disqualified from holding an office under the United States. That itself doesn't apply to the presidency. But that's a way in which Congress has used its authority, at least for a partial implementation of Section 3. So there have been ways that Congress has done this in the past and currently, but it does not apply to this adjudicatory process. It doesn't allow states to do it, and it certainly doesn't allow administrative agencies. So we're going to talk a little bit about the text, and I'll defer to my colleague, Mr. Lukowski, but I will just sort of say a few things. No, it's not clear that the Secretary has authority. We think, if anything, the statutory language is very clear that your office does not have authority, and that you've promulgated a form that specifically talks about Section 2 qualifications. The challengers here have admitted that Section 3 is not a qualification. It's a disqualification. And therefore, we probably shouldn't be here, certainly not for a factual hearing, not for 82 or more exhibits in this evidence, which we don't really have an opportunity to present our own exhibits. And I understand the challengers may argue, oh, yes, you have had opportunity. I'm sorry, 2 days is not opportunity. 3 days notice, plus finding an attorney, preparing for something like this on such a speedy approach. Even the Colorado court was unwilling to go down that road. And I would urge you not to. I'd also urge you to look at the activities of other secretaries of state across the country, as well as other courts who have declined to step into this. The last thing I'll say is there's an informal rule, but it's a rule nonetheless. So the rule of democracy. And that's why I quoted Arsenal at the very beginning. And that is when there are questions that arise, when there are possibly ambiguities, which we don't believe exist in this instance. But the framework for courts and the framework for election officials is to allow people to have a choice, to allow people to make choices for democracy. And if they believe, as the challengers do, they can act upon those choices at the ballot box. And that's ultimately how we resolve these conflicts in the United States, is through the democratic processes, rather than finding what we would characterize as very tenuous legal arguments to try and strike people from the ballot and deny others the choice to vote for president. So in this instance, I'll turn this over to Mr. Lukowski.
Before you do, I have a couple of questions.
Yes, ma'am.
So if a candidate were to not meet the qualifications of Section 2, would a secretary have the ability to disqualify them from the ballot?
Right now, the weight of authority is no. So there was substantial litigation in the 2008 and 2012 election cycles for Article 2 qualifications, very specifically President Obama, Senator McCain, and Senator Cruz. There were probably about a dozen legal cases brought. The vast majority of those, in other words, all except 2, and I'm sorry I don't have the citations offhand, but all except 2 said that was a non-justiciable political question that had to be resolved in the Electoral College. There were 2 courts that one administrative agency and a court that engaged in some adjudication and found that I think one was with Senator Cruz, I think one was with President Obama, and found that they were in fact natural-born citizens. But those 2 were the outliers. So I think it's really an open question as to whether your office or any Secretary of State has that authority to do it. The instances in which I think some people have focused on is when there hasn't been a factual issue, there hasn't been a factual question, an admission that a person doesn't meet the qualifications. So in limited instances, some adjudicatory election offices have not allowed that person on. Now in Colorado, what happened in Hassan is it didn't quite get to that point. It said, here's the form, you have to at least attest to it truthfully. Mr. Hassan refused to fill out that form, just as he refused to fill it out in New Hampshire. So that was a slight variation on that, and it didn't fully reach the question. The actual merits of the case didn't fully reach the question. There was some dicta, certainly, that Justice Gorsuch engaged in. So right now, the weight of authority is the answer is no.
So if a 18-year-old secured the requisite 2,000 signatures in the state of Maine required for the primary ballot and completed the form, but acknowledged on the form that they were not, in fact, did not meet the age requirements for the office they sought, I would be required to place them on the ballot?
Not necessarily. That's an issue where there's no disputed fact. So it's a little bit different than an adjudicatory proceeding. That's where a person themselves admits that they do not meet the Article 2 qualifications. So with respect to the President Obama, Senator McCain, and Senator Cruz, there was a factual question as to whether or not they were natural born citizens. In other words, the challenger said, "You're not a natural born citizen." They said, "Yes, I am." And the court said, "We're not going to engage in that adjudicatory process. We're not going to weigh in on that when there is a dispute." So there is limited authority that says when there's not a dispute. But if someone comes up to you and says, I am 35, and you think they're 18, or a challenger thinks they're 18, the weight of the authority has been when there's a dispute, it doesn't go before it doesn't go before a tribunal or an administrative agency. It has to be considered in the Electoral College. That's the weight of authority. There's a split.
So if
But
there
that's
were
not-
if there were an 18-year-old who were submitting a petition and said that they were 35, and I had the Bureau of Motor Vehicles, and I happen to know because of the documentation on file that they are in fact 18, I would be required to place them on the primary ballot?
Maybe. Look, if your documentation for Department of Motor Vehicles says they're 18, and they fill out an affidavit saying, "I'm sorry, that's wrong. I'm really 35. And here's my birth certificate." Even if the weight of authority is that you don't make that adjudicatory decision. And normally I think what happens is that person will be subject to perjury and potential prison or lying under oath. So that's generally viewed as the sort of enforcement mechanism, is that it would be considered perjury. And so there is an approach for that. But I would say that's not entirely clear. That's not entirely clear. The other thing I would say is that's not what we're talking about here. We're not talking about an Article 2 qualification. We're talking about a Section 3 disqualification. And furthermore, we strongly contest the arguments that President Trump ever engaged in insurrection. That is a highly complex issue. Well, we don't think it's that complex. But it involves First Amendment issues under the Brandenburg versus Ohio standards, because all the evidence that they rely upon are political speeches. It relies upon an interpretation of whether engage includes incite. So it's a very complex disqualification issue, which is fundamentally different than the Article 2.
So that brings me to Section 3. So if it were an office that was named in Section 3, that was an individual that was clearly disqualified under Section 3, would I be required to place them on the ballot?
Probably. And here's why. Section 3 does not talk about eligibility. It says no person shall be, so we're talking about someone whose name. So that would be a senator, representative, or member of the Electoral College. So it says, under the language, it says no person may be a senator, representative, or presidential elector. The reason why it's different is because that person could be elected or chosen as a presidential elector, stand up, be prepared to serve, and Congress can, by 2/3 vote, remove that disability. In fact, there's an argument that under the Amnesty Acts in the 1870s, that was an ongoing removal of any disabilities for anyone who may qualify under the otherwise qualify under the terms of Section 3, because Congress was getting inundated with all these requests, and they kept saying, "Yes, you can serve. We believe you now, even though you were a former Confederate. We believe that you can appropriately serve the United States, consistent with an oath to support the Constitution." So to adjudicate in advance of a person being a senator, a representative, or an electoral college elector would essentially strip Congress of its ability. It would remove that choice for Congress to be able to consider that and remove a disability by a 2/3 vote. It's sort of analogous to the constitutional requirements for being a representative or a senator. A representative doesn't have to be a resident until they hold office. It's either hold or elect. I don't have the exact language. Same with a U.S. senator. So a person can run for U.S. Senate in Maine, living in Colorado. I could run for, I'm not about to do this, but I could run for U.S. Senate in Maine. Perfectly consistent with the U.S. Constitution. But I would have to live here and be an inhabitant of the state at the time I took office. So that's the analogy here. And you see that wired into the Constitution, the organic Constitution. A representative doesn't have to be an inhabitant of a state to run for. Now that's different. Most states require residency in the state, oftentimes for a period of a year before they can run for office. So a state has authority over state officials to behave in different ways. But if we're talking the listed offices in Section 3, senator, representative, or electoral, or elector, that doesn't take effect until they are about to be an elector, be a senator, or be president by the very terms of Section 3.
Do I have any authority to invalidate a primary petition if the statement that the candidate meets the qualifications of the office that the candidate seeks is untrue?
If it's admittedly untrue, likely yes.
Admittedly by whom?
By the candidates themselves, that there's no factual dispute. So the secretary in Colorado was questioned along these exact lines by me. And what they ultimately said their standard was it has to be an obvious and uncontroversial fact. That's what they argued. I don't know if that distinction will survive in the Colorado Supreme Court based on the question. Hassan, there's dicta to indicate that that's correct, both the Hassan case in New Hampshire and the Hassan case in Colorado. There's dicta to indicate that that would be the correct, that you could bar them if it's an admitted fact. But it's a little bit murky in this area, I'll admit.
I have one more question, and it may be a question that you wish to defer to your colleague, but Section 336(3) requires a consent to contain a declaration of the candidate's place of residence and party designation, as well as, quote, a statement that the candidate meets the qualifications of the office the candidate seeks. Is there any difference between the declaration and the statement? And does that distinction, if any, affect my authority in this matter?
So we don't think there's a distinction, but I'm going to defer to Mr. Lukowski. I would note if you look at the structure, that's focused on residency. And if you look at your interpretation of that statute, your interpretation has been very clear. That's the Article 2 qualifications, not a disqualification, for example, under Section 3, or a disqualification under the term limits requirement, or a disqualification under Amendment 25. So those are all additional issues, all of which I think would require sort of substantial analysis. So, for example, under the 25th Amendment, there's a very strong argument, one we've asserted before, that if a president is elected, a person is elected, and let us assume that the Section 3 qualifications apply, disqualifications apply, that person under the 25th Amendment would not take office, the vice president would take it, until that disqualification were removed. So there's actually a mechanism in the U.S. Constitution for handling something like that. Again, that indicates that that the term limits, Amendment 25, the Section 3, that constitutional structure contains those corrective or appropriate procedures to take place in these instances, because they're not qualifications under Section 2. I hope that partially answers, but to the extent I have an answer, I'm going to defer to Mr. Lukowski.
Certainly. Thank you.
Thank you for your attention. I appreciate it.
Thank you, Madam Secretary. If I may, I'd like to make about 3 points here. The first is to focus in on that language in 336. If, pursuant to the challenge procedure, Section 337, any part of the declaration is found to be false by the Secretary of State, the consent and primary petition are void. What this means is that your authority under that section and to review under 337 is limited to the truthfulness of the words on that document. It's limited to the truthfulness of the consent. There is no dispute here that the words on that document are true. The challengers have not disputed anything President Trump said in that form, nor can they. The only thing he's represented is that he meets the Article 2 qualifications, because that's all that was asked of him. And the form itself is very clear that all that is required is that you attest to what is listed above, and that is those 3 qualifications. Now, as you indicated, there's a bit of a distinction here in the language of 336 between statement and declaration. And that is significant. When different words are used in different statutes, they mean different things. And here you have that distinction being made. And that distinction makes sense, that you can challenge the declaration where you're talking about things like residency, which is a verifiable fact, versus qualifications, which the text of the Constitution commits to Congress rather than the Secretary and rather than the states. So if we go back to the text of the Constitution, there's a clear textual commitment to Congress to resolve those disputes, not to the states, not to individual offices. There's a prudential reason for that. An alternative finding would lead to potentially chaos. You could have 50 different standards. You could have 50 different outcomes. You could have cases where a presidential candidate is qualified in some states, not others. And that would be very bad for our democracy. And that's something that the Constitution does not permit and does not require. Now, if we look at the text of the Constitution, we can see why that is. If you go through kind of the sections, it assigns the authority to Congress to evaluate the qualifications for the president, and it sets forth a criteria for what happens if it turns out that a president who is elected is not eligible to serve in office. It provides a criteria for that. So they've already thought of that, and it's already been assigned to Congress. And that's why when several courts have looked at this, they've concluded that there's a clear textual commitment to Congress for that authority. Now, the final point I'll make on that is if we look at U.S. term limits, which was a Supreme Court case a couple decades ago, we look at a case out of the Ninth Circuit, Schaefer v. Townsend. What that indicates is that states can't add to the qualifications to hold federal office. The U.S. Constitution sets several qualifications, and states can't add to them, even by kind of moving up or down the deadline for when those qualifications apply. So as my colleague alluded to, when we're talking about, say, a residency requirement, there's a residency requirement in the Constitution that takes effect at a certain time. In Schaefer, though, what the Ninth Circuit determined was that the state itself can't bump that time frame up. The time frame that is set in the Constitution is the time frame, and if you change that, you're effectively adding a new qualification, which states are not permitted to do. Now, when we're talking about Section 3, any disqualification under Section 3 does not take effect until it's time for an individual to hold office. Section 3 does not talk about being elected to office. It does not talk about being on the ballot for office. It talks about holding office. That means that any qualification or any assessment of disqualification under Section 3 cannot happen until it's time for an individual to hold office. And bumping that process up would violate the U.S. term limits and would violate the principles of Schaefer in the Ninth Circuit by adding extra qualifications. In other words, people can be on the ballot who are ineligible under Section 3 of the 14th Amendment. To be clear, we're not saying that President Trump is. We're saying that people can be on the ballot, they can be elected, and then it'll be up to Congress to determine kind of what to do about that. For example, Section 3 has a safety valve. If you have a clearly disqualified person, they can lift that disqualification. So there's a process by which even a clearly disqualified person can hold office, but in order to get there, they have to be elected. And so any sort of effort to disqualify someone from the ballot prior to that point is adding an extra qualification, which is not allowed under the Constitution.
So if states can't add a disqualification, are they free to ignore the qualifications? Could a state willfully place on the ballot and a candidate that did not, or are we required to place on a ballot a candidate that does not meet the Section 2 qualifications for federal office?
So can a state? Certainly. And states have placed on the ballot people who are not qualified for office for various reasons, usually either age or citizenship. So certainly someone can be on the ballot now, and then the people can choose whether or not they want to vote for that person, knowing that they will not be eligible to hold office.
Must they? As my colleague indicated, the weight of authority says that yes, the states really shouldn't be doing that. But even if you were to disagree with that, that's not the case here. This is not clear that this is. Those would only apply in circumstances where it's clear that at the time that person cannot hold office, whereas that would not be the case here. And as an example of that, President Biden, when he was first elected to the Senate, was 29 years old. He was elected prior to the constitutional age to hold office. He was able to be elected because he would be 30 before taking office. And it would be the same thing. So under that principle you're kind of enunciating, you would have a situation where someone would be disqualified from being on the ballot, even though they could actually hold office due to intervening events between the time of the election and the time of taking office.
And in the case that it was clear that they couldn't meet those qualifications by the time they were going to hold office, because similarly in Maine, you can vote when you're 17 as long as you're going to be 18 on election day in November. So please elaborate or elucidate further. Is a Secretary of State who's responsible for the integrity of the ballot required to place on the ballot people who are clearly disqualified or do not meet the qualifications, rather?
So the weight of authority would suggest yes. However, you don't need to resolve that question one way or the other in this case, because it is clear under the 14th Amendment that even if there were a disqualification, it could be lifted. So it's impossible for it to be clear that someone cannot hold office under the 14th at the time of the inauguration under the 14th Amendment.
You made an additional point earlier in your argument. You said something to the effect of a 50 states differentiation. Can you repeat that argument?
Sure. So if we were to hold differently, if we were to determine that each Secretary of State can evaluate contested qualifications on their own, you run the risk of chaos. And this is something that several courts have noted, including within the last month and a half, the Michigan Court of Claims in evaluating one of these challenges. And this is part of why, as my colleague noted, there's a requirement to have authorizing legislation, because otherwise you have 50 different processes by which people are evaluating contested qualifications. In Colorado, it was a 5-week procedure. Here, it's been about 5 days. In other states, there may be a different process. You have potentially 50 different standards. Is it a preponderance of the evidence standard? Is it clear and convincing? Is it 50% plus one? What's the standard for determining if there's a disqualification? And then as a practical matter, you have the potential for different outcomes based on kind of how those processes play out. So you have the prospect of a person who is campaigning and seeking to hold national office, being on the ballot in some states, off the ballot in other states having a whole separate contested process. And that would lead to chaos. That would be bad for our democracy because it would be unclear what the rules of the game are. The Constitution does not allow or require that. It gives Congress the authority to settle those disputes.
And yet Congress also deferred the ballot access to the states. Indeed, there are 50 different sets of requirements for access to the ballot, including the presidential ballot. To access the ballot in Maine is different than access to the ballot in Colorado or Michigan. So how does your argument comport there? Doesn't that, and indeed, don't we see across the country that there are different states, in fact, next door in New Hampshire, where President Biden did not qualify for ballot access and yet has qualified in Maine?
So Schaefer and U.S. term limits speak directly to this question. So I would I don't want to refer you to those, but I would refer you to those cases for a more coherent explanation of that. But the basic principle is that states can have basic qualifications to sort of manage their ballot. It's the idea that you don't have to have 1,000 people on your ballot, but that if it goes beyond that, it becomes an unconstitutional qualification. So that was kind of the issue in term limits, and that was the issue in Schaefer, and the Supreme Court has spoken to that question of there is a distinction between those basic ballot access rules and these more substantive qualifications. And when it becomes more substantive, it becomes a qualification.
So you're contending that ballot access is merely housekeeping or ballot control? Sure.
Sorry to be bouncing back and forth. So ballot access is governed by, under the federal constitution, Article 1, Section 4, which states that the states may set forth the time, manner, and place of elections. So those essentially are procedural approaches: the time, the way in which the votes are cast or elected, and the place where it happens. That's different than the substantive qualifications. In addition, I think it was ACRU, I believe, versus Myers. It's a case out of Colorado, actually, which involved a ballot issue question. But there's very clear U.S. Supreme Court authority that says when the state grants the electorate the franchise, then other constitutional requirements come into play, such as freedom of speech, due process, equal protection. So if you look at the presidential election, there's no requirement in the federal constitution to even allow people to vote for president. Under the federal constitution, the legislature can make those choices. And in fact, that's how it was originally contemplated. But states have granted the franchise to people to be able to vote for president, who then, and essentially a slate of committed electors. That's a time, manner, and place in which the state's allowed to do that. But the state's required to follow the other substantive provisions of the U.S. Constitution, such as due process, equal protection, freedom of speech, in the way they implement the time, manner, and place, those procedures. Along the same lines, states are required to follow the qualification and disqualification framework set forth in the U.S. Constitution, despite the fact that they can choose the time, manner, and place. So there's a very clear difference between Article 1, Section 4 and the Article 2. I would also note that Article 1, Section 4 states that the time, place, and manner of elections shall be prescribed in each state by the legislature thereof, but that from time to time Congress may make regulations. So essentially the states have first crack at that, but if Congress wishes to step in, and they may do so. So ultimately the time, manner, and place is still subservient, or still must defer to federal law and federal requirements. In this instance, there's multiple bases for those federal requirements. One is the substantive constitutional requirements or qualifications for president. In other words, the state couldn't exercise its time, manner, and place power to add a qualification, as my colleague was saying, nor can it move up the deadline, nor can it import what is a disqualification of the 14th Amendment and turn that into a qualification. And so, and I just want to answer your other question where you had asked, is a state required to remove someone who doesn't meet those requirements? The answer is no, a state's not required. In fact, if you look at the history of the 14th Amendment, it was passed in the 1860s. At that time, we did not have the Australian ballot reforms. They didn't go into effect until the 1890s. So in other words, states did not print ballots. We didn't even have these proceedings because secretaries of state, no one in the government said this is the official ballot that you vote on. Well, it just didn't exist as states hadn't done that yet. What happened is people would show up, they take a ballot that was normally printed off by a political party, and take that and put it in a ballot box. So there'd be different shapes and sizes of ballots that were counted. So Congress and the ratifiers with the 14th Amendment never intended to prohibit people from being able to put a particular name in the ballot box. So people could vote for whomever they wanted, even if that person did not meet the eligibility requirements. So a state's not required to remove them. Obviously, it would be ill-advised for a state, and they can control their ballot in some ways. And of course, you posited the issue is if there's a clear violation of Section 2. Again, that's different in a couple of ways. One, it assumes there's an admitted fact. And two, it's qualification rather than a disqualification. But you're not required to remove someone under the federal constitution.
Thank you. Do any other parties wish to offer argument on this issue?
Yes, I would like to.
Attorney Gordon, you may proceed.
Okay, Madam Secretary, you are exercising the authority that is granted to you by the Maine statutes, Section 337. I would say that no state statute can authorize you to facilitate a violation of the federal constitution. So even if Section 337 and other parts of the Maine code were interpreted to say you have no discretion, well, the authority that you are being granted cannot include facilitating a violation of the U.S. Constitution. I think that's important. If, say, for example, George W. Bush or Barack Obama submitted their petitions and they had their consent form where they said they meet the qualifications of age and natural born citizenship and residence, you would be authorized to keep them off the ballot because to do otherwise would be facilitating a federal constitutional violation.
Thank you. Would counsel for Mr. Trump like to respond to that argument? And I do remind the parties that there will be an opportunity. We will be providing an opportunity to submit a legal brief at the conclusion of these proceedings to be submitted by Monday, so that parties can further develop any arguments in response to evidence or argument made today.
I'd just like to clarify, nothing here would even assuming their position were correct would require you to facilitate a violation of the Constitution. Merely being on the ballot is not a violation of the Constitution. People regularly vote for people who are ineligible for one reason or another. People regularly write in names like Mickey Mouse. We don't hold them off to jail for violating the Constitution. So this is not a question of facilitating a violation of the Constitution. It's a question of accessing the ballot and allowing people to express their views through the ballot.
Thank you. Do any other parties wish to offer argument on this issue? Okay.
Madam Secretary,
Yeah.
I'm assuming based on what you just said, we won't ask for rebuttal. We'll rely on post-hearing briefing and the testimony of Professor Magliocca to respond to these arguments.
Certainly. If you wanted to offer a brief comment, you could, but we will be accepting legal briefs developing further any arguments that are raised today or any additional arguments you wish to provide. Okay. I want to inquire, have the parties been able to exchange evidence that is being submitted today?
We've received a majority of the evidence items. We haven't had time to view them, and many of them are on a USB stick. I don't have an adapter for to be able to view.
Has the Secretary of State's office received the evidence that's been provided by the parties at this time or not yet? Okay. Okay, we're going to provide a 15-minute break for the parties to negotiate exchange of the potential exhibits. Before they do that, the parties have conferred on whether any exhibits may be entered into the record without objection, correct?
Yes, I believe we've not objected to 5.
Okay. Can we name those exhibits that have not been objected to for the record?
Certainly. Exhibit number 1, President Trump's signed consent that's on file with the Secretary. Number 2 is the petitioner's submitted challenge. Frankly, we don't believe that that's appropriate as evidence, but it's certainly part of the pleadings, so we don't object to you looking at it. But we do not agree to the truth of the matter asserted in any of it. Items 3 through 5 are voter registration records of Ms. Rosen, Mr. Civiello, and Mr. Strimling. Those are on file with the Secretary. We don't object to those.
Does that conclude the evidence that's being accepted without objection?
Yes. Madam Secretary, may I make a comment about the evidence?
I think we're going to break for 15 minutes, and then there will be an opportunity to object to evidence or to comment on evidence at the appropriate time.
My suggestion may streamline things if you may just hear me out.
Okay.
it is impossible for us to give any meaningful approach. I know a lot of these even come from Colorado, but I would have to read through every single one of them.
That sounds like argument. Well, wait.
Well, but if I may say, what I would suggest, if I may, is simply accept them under advisement, allow us to provide a written briefing if in fact we object to the authenticity and to the relevance of them, and then they can respond and we can reply. I think that would be the appropriate way to give us any meaningful opportunity, because there is no way I'm going to be able to download what looks like dozens, scores of megabytes of data, go through all of it, formulate appropriate objections in our mind, properly supported, to be able to provide something meaningful to this court. This is, and I don't mean to sound pejorative, but this is ambush litigation in a sense. Now, if you want to simply look at it and give us an opportunity to weigh in a considered manner, I think that would be best. But I will tell you right now, there's no way we're going to be able to look at this, determine authenticity, and give you a proper response, especially since we didn't even get them until an hour ago. And there's over 80 of them, and there's dozens of megabytes of data.
Attorney Kilbreth, do you have objections to the suggestion that they be admitted conditionally and then parties be permitted to brief objections and responses to those objections?
Well, I think that may be workable. It's a little unclear to me what Mr. Gessler has in mind about the timing of his objections and so on. Is that a post-hearing objection? Or is it in the middle of the hearing? What is your contemplation?
However one wants to characterize it. I want an opportunity to be able to look at this, to consider it, to think about it more than 5 minutes, and then to submit an objection.
Well, let me respond to that point. I think that, Madam Secretary, you should be aware of the fact that the overwhelming majority of those exhibits are from the trial in Colorado, which Mr. Gessler was a full participant in. The transcripts, for example, we have introduced are the transcripts of all the testimony, including the testimony of his witnesses. I think this objection is a little over the top, given his involvement in that case. But I don't object to a process that gives them an opportunity to object. All I want is, if we are going to admit them conditionally, we get to proceed with the case as if they were admitted, and he can object subsequently.
That sounds like what you had proposed, Attorney Gessler.
Similar. I mean, I'm certainly interested in how we proceed as if they've been admitted. I mean, my understanding is you have one witness, who's Professor Magliocca. I believe he's going to testify to legal conclusions, and then closing argument. If that's all we're talking about, that's fine. I think it's properly handled in written briefing.
Attorney Kilbreth.
That's not all we're talking about. What we're talking about is a presentation of the evidence that we want to admit, and Professor Magliocca's testimony. We don't believe there's any legitimate authentication issue. We have an affidavit from Mr. Sherman authenticating all the exhibits, and we ought to admit the exhibits and move on. And if they want to object during the presentation to a specific thing, I suppose that would be appropriate, because that's the normal course.
Well, Madam Secretary, I'll make this easy. We object to it all. It will be a blanket objection. You want to overrule that and allow this in, but we have not had an opportunity to consider these. I understand the authentication issues, but yes, and I live part of it. We certainly have relevance issues as well, but I haven't even had a chance to look at them to determine whether or not we do have authenticity objections. And
I'm going to pause because we want to make sure that we are following the procedures under the Maine Administrative Procedure Act and that we're following the rules of this hearing. So I'm going to pause and confer, and we'll circle back in a second.
Thank you.
We're going to take a 10-minute break to confer on the advisability of how to proceed in congruence with the Maine Administrative Procedure Act. I really appreciate both sides putting forth two alternative solutions for discussion and our reflection. We do have some technical assistance here in this room from the Department of Secretary of State who may be available potentially to assist in technology transfer. So I encourage the parties to be finding a way to share the exhibits that are proposed as we confer on the process as well. Ms. Royal?
Yes, I would like to object to any suggestion that this hearing that I was called to today to present my challenge be suspended for any reason or be deferred to a different day and time. I would like to be able to proceed today to present my challenge.
We're not suggesting that the hearing be suspended. You will have an opportunity to present the challenge. So that is, the objection is not ripe at this moment because that has not been proposed. We are merely taking a 10-minute break to resolve the question in terms of the evidentiary portion of the hearing. And I understand that this may be a different type of hearing than some of the observers online may have experienced, even though we're in a legislative hearing room. This differs from a public hearing before the legislature. It is a hearing governed by the Administrative Procedure Act in Title 337, excuse me, Section 337 of Title 21A. Thank you. Welcome back. I'm Secretary of State Shenna Bellows. This is the hearing of challenges of Kimberly Rosen, Thomas Aviello, Ethan Strimling, Paul Gordon, and Marianne Royal to Donald J. Trump, Republican candidate for President of the United States. We were paused for those listening and observing in the audience who may be unfamiliar with the Maine Administrative Procedure Act. It is not like a legislative public hearing where people can just speak their piece. There are specific rules and procedures. And one of those rules and procedures is an evidentiary hearing. We were discussing the fact that the counsel for Mr. Trump have not been able to review the evidence due to technical difficulties and the tight timeline of the requirements of Title 21A, Section 337, which requires that a hearing be held within the 5 business days of the challenge itself. So the timeline by statute is compressed and makes difficult the exchange of evidence. So we believe we have agreed conditionally on a process. And the procedure that we are going to follow without objection of the parties is that the challengers shall move into the evidentiary portion of today's hearing exhibits that they wish entered into the record. My understanding is that counsel for Mr. Trump will then object to those exhibits that have not been consented to. I will then provisionally admit those exhibits for purposes of today's hearing and presentation, subject to briefings on the objections by the parties to be submitted to me by Monday by 5 p.m. If the objection is sustained, then the evidence presented will not comprise any part of the record or the determination and the decision that is made on this matter. If the objection is overruled, then the evidence would enter in. Is there any objection to that particular aspect of the process? Then without objection of the parties, I will invite the challengers to submit any exhibits for purposes of the evidentiary hearing for today's hearing.
Thank you, Madam Secretary. We'd move into evidence the exhibits we submitted, the challenger submitted, which I think are numbers 1 through 6 through 87. In addition, we'd move the admission of the documents attached to the affidavit of Donald Sherman. And finally, we'd move the admission of the 3 documents. I think they were included, but there are 3 documents for Professor Magliocca, a CV, a list of articles, and his amicus brief. And with respect to the amicus brief, I just note that Mr. Trump's lawyers submitted an amicus brief when they filed their filing last night. So that seems to be standard procedure.
So exhibits 6 through 87 are being submitted, and they will be numbered as exhibits 6 through 87, exhibits 1 through 5, having been admitted previously by mutual consent of the parties. Then there will be, and in fact, Professor Magliocca's exhibits are part of exhibits 6 through 87. I'm looking at the list here. Then exhibit 88, 89, and 90 will be 3 documents provided by Mr. Sherman. Is that correct?
No, Mr. Sherman's affidavit provided, I think it's 25, 20.
The affidavit of Donald Sherman, Madam Secretary, includes 24 exhibits as attachments, which were filed separately with your office yesterday.
Okay. So what you were submitting is exhibits 6 through 87 of your original submission, and then exhibits 88 through 111, which are the additional 24 exhibits provided by Donald Sherman. Is that correct?
Yes.
Okay. Is there an objection to the exhibits?
Yes, Madam Secretary, we object to all of it. We recognize that you will be hearing it for purposes of argument today, but obviously we object to all of it, and we will provide a written argument as to the basis for our objections.
I will provisionally admit the exhibits into the hearing for today's, for purposes of hearing the evidence contained in those exhibits. However, I invite the parties to brief the objections and in response to the objection by Monday, 5 p.m. to my office. And I will then make a determination as to whether the objection is sustained or overruled at that time.
Madam Secretary, I don't think we'd be able to respond to whatever objections they raise at 5 p.m. on Monday because we'll just see them then.
Okay.
So if we could have an additional 24 hours, I'd appreciate it.
So granted, the brief outlining the objections and the nature of the objections to exhibits 6 through 111 is due Monday by 5 p.m. A brief that responds to those objections is due Tuesday by 5 p.m.
Madam Secretary, may I ask, with respect to the timing, I know you've also stated your desire to listen to have briefings on the issues. I'm just looking at the time frame. I mean, if we finish today, I assume sometime late this afternoon or early evening, it's difficult for us to provide. It's a very short time frame for us to give you fulsome briefings. What are you thinking then as far as the written closing arguments?
So written closing arguments will be due Tuesday by 5 p.m. as well. And I understand there was a brief outlining significant arguments submitted by counsel for Mr. Trump yesterday. That brief would be accepted. Should that be your desire to have that be your brief, or you may modify it, of course, or submit whatever you like. But it's Tuesday by 5 p.m. will be the deadline for all parties to provide any closing briefs. It is almost 12:30. We are going to break for lunch. We will return promptly at 1 for the evidentiary portion of this hearing.
Madam Secretary, may I just for the record, I know we had discussed this a little bit earlier. We obviously will object to the evidentiary hearing. Our view is that the agency should make a determination on its jurisdictional, its ability to even consider this evidence. We think it's pretty straightforward under sections 336 and 337 that the office does not have jurisdiction to consider this. It's the only meaningful fact here is President Trump's consent form, and there's no challenge to the truthfulness of anything he stated in that form, and there's no challenge to the propriety of the form, and that should be the end of it. And we should not have to move to this evidentiary hearing. So the jurisdiction is a threshold question. This tribunal should consider that, make a ruling on that before we even go towards the evidentiary hearing. So I want to at least lodge that objection before we start the evidentiary hearing.
Objection overruled under the Maine Administrative Procedure Act. An evidentiary hearing is not only acceptable but required. We are now going to break for lunch.
I am sorry, Madam Secretary.
You have another objection?
It's not an objection. It's just also I had 3 small exhibits that I had submitted on Wednesday.
Okay.
These were simply PDFs of news articles with widely reported things that Mr. Trump has said. I have not heard of any objections to that, but I just wanted to bring that up so that's not applicable.
Okay. For the record, Attorney Gordon has submitted exhibits Gordon 1 through 3. Is there an objection to exhibits Gordon 1 through 3?
Yes, we object to it.
Okay.
And I would note for the record that Mr. Gordon and I were college roommates and have not seen each other for 40 years at this point.
And it's good to see you again.
It's very good. And I probably would have objected 40 years ago too. But we will object subject to the written briefings as well.
Similarly, I'm going to provisionally accept Gordon exhibits 1 through 3, pending legal briefs regarding the objection. Legal briefs regarding the objection to Gordon exhibits 1 through 3 are due Monday by 5 p.m. to the Secretary of State's office, and a reply brief to that is welcome, but must be received no later than 5 p.m. on Tuesday to the Secretary of State's office. Are there any further exhibits to be introduced by either side or any interveners?
Your Honor, just briefly, and we can discuss it after the lunch break, but under Title 5, Section 9057, Mr. Sherman's affidavit is admissible if he's subject to cross-examination, and we have made him available for cross-examination. Should President Trump's lawyers choose not to cross-examine him, I just want to flag for Madam Secretary that he is and was available, should that come up.
Thank you. So noted. Any other exhibits at this time? We will be breaking. We will still return promptly at 1 o'clock, and the hearing will resume at 1 o'clock for the evidentiary portion of the proceeding. Thank you very much. Welcome back. Thank you, everyone present here for the challenges of Kimberly Rosen, Thomas Saviello, and Ethan Strimling, Paul Gordon, and Mary Ann Royal to Donald J. Trump. There is an echo. Can we mute one of the computers? Okay. Well, welcome back to the public hearing on the challenges of Kimberly Rosen, Thomas Saviello, and Ethan Strimling, Paul Gordon, and Mary Ann Royal to Donald J. Trump, Republican candidate for President of the United States. In the morning, the parties introduced themselves. We heard argument on the threshold question of my authority as Secretary of State to make a decision on the substance of the allegation that Mr. Trump is not qualified for office under Section 3 of the 14th Amendment and Section 1 of the 22nd Amendment, such that the information contained on his candidate's consent form is false and his petition is invalid under Title 21A, Section 336(3). At this time, we're in the evidentiary portion of the hearing. But before we proceed, are there any considerations or any matters that arose during the break that either party or any of the parties wish to raise before moving forward?
Yes, Madam Secretary, this is Scott Kessler for the record. We had conversation with Mr. Sherman and his attorneys at Crew, and we think we have a workable solution. So Mr. Sherman is intending to authenticate a number of items from the Colorado proceeding. What our proposal, and I'm sure counsel can disabuse me of this if I get this incorrect, would be to hold that in abeyance we'll review the exhibits for authenticity. If we have any questions, and to be frank, I don't anticipate any, but if we have any objections, they would make Mr. Sherman available by video conference Monday morning, and we could cross-examine him on any there. I think there's a very, very slim chance that'll happen. That'll at least give us an opportunity to review everything he's listed in his affidavit, just double check it ourselves. And if there's no objections, then we will, to authenticity certainly, then there'll be no need to call him on Monday morning.
I would agree with Attorney Gessler that that is what we discussed. And if that is Madam Secretary's desire, we would be happy to go forward in that direction. If not, my client and witness is here.
Thank you. We'll confer. Thank you for that proposal, counsel, and for that agreement, opposing counsel. With the consent of the parties, we will agree to the video cross-examination of Mr. Sherman, should that be required, to verify and validate the authenticity of the exhibits before us. Counsel should alert the Secretary of State's office by 5 p.m. on Sunday as to whether cross-examination is required. If cross-examination is required, we will do it by public video conference presided over by me on Monday morning at 10 a.m. Eastern Time. But again, counsel must inform me by 5 p.m., no later than 5 p.m. on Sunday.
Okay.
Thank you, Madam Secretary.
Let's just for the record, is there consent from both sides?
Yes.
Yes, there's consent from President Trump.
Excellent. Thank you. So we'll now proceed to the evidentiary hearing. And for this process, it is necessary to swear in the witnesses on the matter. And Ms. Royal has requested to be first. So Ms. Royal, I'm going to ask you to step to the podium. And before we begin, I'm going to swear you in. There's a button right there that should be. There you go.
Thank you.
Would you please state your name clearly for the record?
My name is Mary Ann Royal.
Would you please raise your right hand? Do you solemnly swear that you will tell the truth in your testimony at the hearing today?
I do.
Thank you. You may proceed with your statement.
Thank you. I need to amend my written comments to read, "Good afternoon, Madam Secretary and Assistant Attorney General Anton. My name is Mary Ann Royal. I live in Winterport, Maine. I am not a lawyer. I am not a constitutional scholar. I am not a historian. I am an ordinary citizen of Maine who is grateful that Maine has granted me the right to file this challenge. I am here to protect and defend the Constitution of the United States in the hopes of preserving this republic by challenging the petition of Donald J. Trump that Donald J. Trump has submitted to appear on Maine's ballot. The framers placed a presidential oath of office in the Constitution, Article 2, Section 1, Clause 8. It requires that the president take the oath before executing his duties. I wish to state that oath for the record. Quote, "I do solemnly swear or affirm that I will faithfully execute the office of President of the United States and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States." Unfortunately, the framers did not foresee any truly patriotic citizen elevated to the position of President of the United States willfully violating that oath of office, and they therefore provided no mechanism for preventing such a person from ever holding that office again. I am aware of no laws that have been broken by the violation of this oath. There is no fine or jail time that can be assessed so a president can repay his debt to society. There is no due process requirement for a violation of the oath of office by the president. The only recourse is left to the states. States must determine whether this person should have access to their ballot. If found to have violated the presidential oath of office, there can be no forgiveness, no second chances. That person must be disqualified for having willfully disregarded the duty to preserve, protect, and defend the Constitution of the United States. And there is no doubt that Donald J. Trump willfully violated his oath of office to preserve, protect, and defend the Constitution while he was President of the United States. We all saw it. We all heard it. 1, he told his supporters to stand back and stand by. He called his supporters to Washington, D.C. for the express purpose of interrupting the constitutionally required proceedings in Congress to certify the results of the election, or, in his words, to stop the steal. He sent them to the Capitol to interrupt the proceedings. He watched the violence at the Capitol unfold. He did nothing to stop the violence at the Capitol for over 3 hours. He organized, he welcomed, he sent, he watched as president and commander-in-chief, and did nothing to stop the assault on the Capitol, which had the effect of bringing to a halt the constitutionally mandated procedure for certifying the election. He refused to act to stop the assault on the Capitol, on the members of Congress, and on those sworn to protect the members of Congress, despite repeated pleas to do so. In doing so, in that 3-hour period, he violated the oath he took to preserve, protect, and defend the Constitution of the United States on 2 counts. One, as President of the United States, demanding that the certification of the election, be stopped, and 2, giving aid and comfort to those he assembled to stop the certification of the election. It is this violation of his oath that should be grounds for disqualifying him as a candidate for the office of the President of the United States on Maine's ballot. To be clear, I am not invoking the 14th Amendment of the U.S. Constitution. I am not talking about treason or sedition. The only section of the 14th that I am addressing would be this section that talks about having taken the oath. I leave the discussion of treason and sedition to others to argue here and in other venues. Mine is a novel challenge. It may even be a precedent. I am asking you, as Secretary of State, to focus only on the presidential oath of office requirement to preserve, protect, and defend the Constitution, and what a violation of the presidential oath of office means to Maine. No person who has taken that oath of office and then violated that oath so egregiously can ever be trusted to hold any public office again. There is no mechanism for repaying such a debt to society. There can be no forgiveness for one who seeks to undermine the Constitution of the United States. There can be no second chance for one who seeks to undermine the Constitution of the United States. If we allow individuals, no matter how popular, access to our ballot after having violated their oath of office, we undermine the very foundation of our republic. It is my sincere hope that you find that the breach of duty engendered by the violation of his presidential oath of office is just cause for denying Donald J. Trump access to our ballot. To do otherwise would be to turn your back on the Constitution, to render meaningless the presidential oath of office, and, I might add, jeopardize the integrity of our elections. I am asking you to deny Donald J. Trump access to our ballot. His primary petition should be deemed void because he violated his oath of office by refusing to preserve, protect, and defend the Constitution of the United States while he was President of the United States. Should you deny my challenge, I respectfully request that you cite state or federal statute or sections of Maine's Constitution or the United States Constitution that would prevent you from accepting my challenge. I do not believe there is anything preventing you from deciding that a violation of the presidential oath of office is sufficient cause to deny Donald J. Trump his petition to appear on the Maine ballot. Thank you for the opportunity to be heard. And as an aside, it is interesting to me that Maine law states, quote, a person commits a Class D crime if that person, A, is a public official and knowingly fails or refuses to perform a duty required of that official under this title, Title 21A, Elections. And Madam Secretary, if you would humor me, I would like to leave my written testimony, with my signed written testimony with you today.
Yes, of course, that's fine.
To whom should I give it?
Please, my executive assistant, Mary Kate, will accept it.
Thank you very much.
Before you leave the podium, is there any cross-examination from any parties?
No, Your Honor.
Yes, we could just ask 3 questions.
Sure. Please proceed.
Do you believe President Trump is a natural-born U.S. citizen?
I don't know how that's relevant to my testimony.
So please proceed with answering the questions that they ask.
Okay.
Unless you object to the question.
Would
You may object to the
Would you
question.
repeat the question?
Sure. Do you believe President Trump is a natural-born U.S. citizen?
I have no reason to believe otherwise.
Do you believe he's been a resident of the United States for at least 14 years?
I have no reason to believe otherwise.
And do you believe he's at least 35 years of age?
I definitely have reason to believe that's true.
Fair enough. No further questions.
Thank you. Thank you very much, Ms. Royal. Please, you may give your written statement to Mary Kate. Attorney Gordon, were you intending to present as a witness in this portion of the proceeding?
Yes, I am. I have just a brief statement that I was intending to make.
Okay, please proceed to the podium.
Thank you.
And Attorney Gordon, are you intending to testify, in which case we'll swear you in?
Yeah, you can swear me in.
Okay. Would you please state your name clearly for the record?
My name is Paul Gordon.
Please raise your right hand. Do you solemnly swear that you will tell the truth in your testimony at this hearing today?
I do.
Thank you. Please proceed.
Good afternoon, Madam Secretary. My name is Paul Gordon. I'm here as a registered voter in Portland. I'm here to challenge Donald J. Trump's placement on the ballot for the Republican Party's 24 presidential primary election. Mr. Trump, who was elected president in 2016, has stated that he also won the 2020 election. This representation that he has been elected to the office of president twice disqualifies him from running again under the 22nd Amendment of the United States Constitution. This is popularly known as the Term Limits Amendment. However, while Mr. Trump has only served one term as president, that actually does not end the inquiry under the 22nd Amendment. That amendment states, no person shall be elected to the office of the president more than twice. That text is unambiguous. It expressly focuses on whether someone has been elected twice, independent of whether they have actually served a second term. Mr. Trump has said on numerous occasions that he won the 2020 election, that he's been elected twice. For instance, on January 4th, 2021, at a Georgia Senate runoff campaign event, he stated, you know, I've had 2 elections, I won them both. Even after Congress counted the electoral votes and confirmed Joe Biden's victory, Mr. Trump has continued to claim that he actually won the 2020 election. For instance, at a rally in Michigan in April of 2022, he said, we did win, we won by a lot, not just a little. And as recently as November of 2023, just a month ago, he stated, we won in the last time, 50 states. Think of it, 50 states. We won every state. Now, I am aware that Mr. Trump, in fact, lost the 2020 election. It was not stolen. He just lost. But that simple fact does not end the inquiry as to whether he can appear on the ballot. Because when a candidate repeatedly, intentionally, and publicly makes a factual representation that, if true, would disqualify him from the office he seeks, I don't think we can simply close our eyes and pretend he isn't saying that. To let someone on the ballot whose own repeated representations would disqualify him from office would not be consistent with the rule of law. And the rule of law is what protects our democracy. It isn't enough if you know that he lost. It isn't enough that I know he lost. If he wants to be on the presidential ballot, he needs to acknowledge that he lost. He needs to do it publicly and unambiguously. He needs to repudiate all previous statements undermining the integrity of that election. There are consequences to his conduct around the 2020 election. And if he keeps on this path, then the consequences are that he cannot run for president again. Thank you.
Thank you. Is there any cross-examination from any parties?
Yes, no
Okay.
questions.
Please proceed.
Good afternoon, Mr. Gordon.
Afternoon.
So let me ask you several of the questions that were asked before. To your knowledge, is President Trump a natural-born U.S. citizen?
Yes.
Okay. And to your knowledge, has he been a resident of the United States for at least 14 years?
Yes.
And to your knowledge, is he at least 35 years of age?
Yes.
Okay. And is it your testimony today that President Trump won the 2020 election?
No, that is not my testimony. My testimony is that he is making repeated public assertions that he won the 2020 election.
So your testimony is that he lost the 2020 election. Is that correct?
He did lose the 2020 election.
Okay. And is your testimony that he won the vote in the Electoral College for president in 2020?
That is not my testimony.
So your testimony is that he lost the election, in your view, in 2020 in the Electoral College?
My testimony is that he did lose that election and that he is representing that he won that election.
No further questions.
Thank you. Any further questions from any cross-examination from any parties? Seeing none. Thank you, Attorney Gordon.
Thank you.
Now, Attorney Kilbreth and Attorney Gaines, before you bring your exhibits forward, without objection from the parties, I would like to provisionally admit the affidavit of Mr. Sherman. Do I have the consent of both parties to provisionally admit the affidavit of Mr. Sherman, pending, of course, the opportunity for the parties to request cross-examination by video conference on Monday?
Yes, Your Honor, on our behalf.
Is that also amenable to you?
Yes, Your Honor.
Okay.
Madam Secretary.
That will be Exhibit 112, will be the affidavit from Mr. Sherman. So Attorney Gaines or Attorney Kilbreth, please, it is your turn to present the exhibits that you already entered in that are provisionally admitted pending the legal briefing regarding the objections. And please definitely use the podium for your presentation.
Thank you, Madam Secretary. Is the plan here to allow me to share my screen via the Zoom?
Yes, do you have access to the Zoom?
I do have access to the Zoom.
Then my assistant, Mary Cadis, will promote you as a participant in the webinar and a co-host to permit you to share your screen. That will be displayed here on the screen that all of the parties present and myself can see, as well as the screen behind me that all of the observers in the room can see. And it will also be streamed online through the Zoom.
Okay. I am somewhat concerned that playing audio is going to make our heads explode with an echo. And I'm going to try briefly one of the clips. Are we sure that's not going to happen?
When you go to share your screen, and I'm going to ask my communications director, Ms. Cook, to stand next to you. Can you not stop sharing your screen? Exit.
So when you go to share your screen, there will be a checkbox that tells you that is about the audio being played through the computer.
Okay.
Yep.
Yes.
Share sound. Yep.
Okay.
That should do it.
Okay.
Let's stop sharing for a moment.
Sure. Sorry.
No, stop sharing for a moment.
Okay.
If we want to pull up, do you have the whatever video?
Well, they're going to be through here.
So when you share those, when you have those windows open and are going to be sharing them, that's when you want to share your screen and put the share sound. Does that make sense?
Kind of.
Okay.
Yes. The alternative is I could, no, that doesn't work. Okay. Okay. This. Now we're going to share screen. We're going to share this window.
Yep.
We'll share sound. Okay. Now does my sound need to be on or?
No, should be fine.
Okay.
Like the sound should.
Okay. This is Exhibit 6 RSS Exhibit 6. This is the inauguration, the 2017 presidential inauguration of Donald Trump.
How can we hear?
Trump do solemnly swear that I will faithfully execute. That I will faithfully execute the office of President of the United States. The office of President of the United States. And will, to the best of my ability. And will.
No, kills the sounds.
We're going to take a 5-minute break for the tech so that we don't all have to watch this. So people can take a 5-minute break.
Okay, stop share. No. Should I go?
Do you want to pull up the video that Mr. Gaines wants to play first? So Mr. Gaines, you're going to direct them to cue and they'll cue for you to play what you wish to have played. You are on the record. We're moving forward the evidence presented by Attorney Gaines and Attorney Kilbreth on behalf of Mr. Strimling, Mr. Saviello, and Ms. Rosen. And if you could turn your mic on, and that way they can know.
Okay. First, we are moving forward Exhibit 6.
Okay.
This is the video of the Trump inauguration, January 20th, 2017. And if you can pull that up to 26 minutes and 30 seconds.
Hold 1 second. Getting there. Exhibit 6. Doing our best to address some technical difficulties in presentation of evidence.
Mr. President, Mr. Vice President, Mr. President-elect, Mr. Vice President-elect, ladies and gentlemen, welcome to the inauguration of the 45th President of the United States of America. Today, the legislative...
We recognize the United States.
Ladies and gentlemen, it's an honor to introduce the Chief Justice of the United States, John G. Roberts, Jr., who will administer the presidential oath of office. Everyone, please stand.
Please raise your right hand and repeat after me. I, Donald John Trump, do solemnly swear.
I, Donald John Trump, do solemnly swear
That I will faithfully execute.
that I will faithfully execute
The office of President of the United States.
the office of President of the United States
And will, to the best of my ability,
and will, to the best of my ability,
preserve, protect, and defend
preserve, protect, and defend
the Constitution of the United States.
the Constitution of the United States.
So help me God.
So help me God.
Congratulations.
Okay, Madam Secretary, moving forward, challengers Rosen, Saviello, and Strimling's Exhibit number 7, the final report of the Select Committee to investigate the January 6th attack on the United States Capitol, dated December 22nd, 2022. I don't know that
Do you
need
wish
to
to
show
share that, or is that a written document to be?
It is a PDF. We
Okay.
don't need to show it on the screen for any reason.
Yeah, okay.
Okay, perfect. Next up is moving forward, Exhibit 8, which is the final order of the court in Anderson, of the district court in Anderson v. Griswold, dated November 17th, 2023.
Attorney Gaines, are you planning to name each of the exhibits that have been entered in?
I was planning that. We can,
I don't think that's necessary because you've entered them in as a batch.
okay,
So are there any exhibits that you specifically wanted to
okay.
highlight, explain, enter into evidence today so that questions may be asked or that you wanted to expound upon? Please feel free.
Perfect.
But the parties are going to brief the objection to the exhibits that have been entered in, and then the response to the objections, so that will or will not, depending on the ruling on those objections, be entered into the record without naming. So please proceed.
Perfect. Thank you, Your Honor, Madam Secretary. Okay, moving forward, Exhibit 38. No, I'm sorry. I'm moving forward, Exhibit 39. And this is video from a Trump October 23rd, 2015 campaign rally. And this was Petitioner's Exhibit 127 in Anderson.
While they pull that out, do you want to describe why you're offering it?
This is I had the wrong notes for that.
We have the speech.
What do
Go
we
ahead and
do?
hit play.
And we gave it the A+ job, and we built something that we love. We built something that we love. Really love. And what happened? I'll let them get out. Go ahead, get them out. See, the first group, I was nice. Oh, take your time. The second group, I was pretty nice. The third group, I'll be a little more violent. And the fourth group, I'll say, get the hell out of here. So
this is shown for Trump's reaction to protesters and addressing the crowd at his campaign rally. The next exhibit is Exhibit 40, is video from a speech by Donald Trump in Birmingham, Alabama on, November 21st, 2015.
do I hear somebody over there? You know, you have one guy over there shouting. We have thousands of people, and you'll read about him tomorrow. They'll say, oh, the room had a picket. All right, yeah, get him the hell out of here, will you, please? Get him out of here. Throw him out. No, we had it the other day. I got criticized. We had it the other night. I had a lot of people, and one guy who was seriously obese. He complained when I mentioned that food stamps, we have a lot of people on food stamps. And the guy went crazy. And they said that wasn't politically correct. Who cares? We all have a weight problem. Yeah, you can get him out. Yeah, get him out. Get him the hell out of here. Get him out of here. Get out. Get him out of here.
Okay, the next, moving forward, Exhibit 41. This is video from a Fox News interview the following day, November 22nd, 2015. Donald Trump responding to questions about what had happened in the previous two exhibits.
You say roughed up. He was so obnoxious and so loud. He was screaming. I had 10,000 people in the room yesterday, 10,000 people. And this guy started screaming by himself. And they, I don't know, rough up. Maybe he should have been roughed up because it was absolutely disgusting what he was doing. This was not handled the way Bernie Sanders handled his problem, I will tell you. But I have a lot of fans and they were not happy about it. And this was a very obnoxious guy who was a troublemaker who was looking to make trouble. But I didn't get to see the event.
Next, moving forward, Exhibit 42. This is video from a speech in Cedar Rapids, Iowa on February 1st, 2016. This is again Trump responding to protesters being present at his rally.
Attorney Gaines, for purposes of the hearing, how does the evidence that you're presenting relate directly to the challenge that's been filed by the challengers?
To the challenge, so this shows a pattern of behavior by President Trump where he encouraged violent behavior on behalf of his supporters at his rallies.
Okay.
There's a series of these clips, each showing Trump encouraging violent behavior and then either condoning or applauding that violent behavior.
Madam Secretary, would you like me to respond on an exhibit by exhibit basis, since I know you sort of want to get this stuff here, or do you want me to wait until after the presentation?
You look like you want to say something, Attorney Gaines.
We're trying to get this through fast, given the conditional nature of it and the fact that we're going to then brief the evidence following the conditional entrance into the record. So we can change approaches to allow that.
How about in terms of groups of themes? So you said you're playing a series of videos that show a pattern of conduct. Perhaps when those end and you're going to a next sort of section of evidence, you could permit counsel to speak in response briefly. Would that be amenable to both sides?
Sure.
Okay.
Yes.
And there is going to be an opportunity for briefs and a reply for brief, of course. Is there a technical difficulty? Possibly. So Exhibit 42 is not software that we have access to. It is not something we can play on our computer.
Okay. We'll go to Exhibit 43 is going to be a video from a speech by Donald Trump in Las Vegas, part of the same group.
He's a great contractor, and he's a great merchandiser, and he cannot get his product into China. No matter what he does, he can't. They send their product. Oh, bye-bye. Good job, fella. Bye-bye. Look, see, he's smiling. See, he's having a good time. I love the old days, you know? You know what I hate? There's a guy totally disruptive, throwing punches. We're not allowed to punch back anymore. I love the old days. You know what they used to do to guys like that when they were in a place like this? They'd be carried out on a stretcher, folks. That's true. You know, I love our police, and I really respect our police, and they're not getting enough. They're not. But honestly, I hate to see that. Here's a guy throwing punches, nasty as hell, screaming at everything else when we're talking. And he's walking out, and we're not allowed, you know, the guards are very gentle with him. He's walking out like big high fives, smiling, laughing. I'd like to punch him in the face, I'll tell you. You know, it brings up something. 2 debates ago.
Okay, the next video in this group is Exhibit 44, video from a speech in Palm Springs, Florida, March 11th, 2016.
So on that point, though, Mr. Trump, you talked about the 2 Donald Trumps, that there may be, Dr. Ben Carson brought that up. When you say things like, you know, I want to punch a protester in the face, or when you said the things about Dr. Ben Carson, is it just politics? Are you playing a character there?
It's politics, and it's fact. Let me just tell you, we've had some violent people as protesters. You know, they're not just people saying, oh, these are people that punch. These are people that are violent people. I get the biggest crowds by far, not even a contest. And, you know, you people don't like to report it, but actually the one thing good about protesters is you have to go into these stadiums, these massive stadiums with 25 and 30,000 people, and you have to, at least you see, because the cameras never turn. Hey, Ben, the cameras never, ever turn and show the stadium. I always say turn and show how the stadium, they don't. But when there's a protester up in the corner, it's great because the cameras all turn. That's the only reason. Because, you know, it's a negative as opposed to a positive, so they turn. But we've had a couple that were really violent, and the particular one, when I said, like that, bang 'em, that was a very vicious, you know, he was a guy who was swinging, very loud, and then started swinging at the audience. And you know what? The audience swung back. And I thought it was very, very appropriate. He was swinging, he was hitting people, and the audience hit back. And that's what we need a little bit more of. Now, I'm not talking about just a protester. This was a guy who should not have been allowed to do what he did. And frankly, if you want to know the truth, the police were very, very restrained. The police have been amazing, but the police were very, very restrained. Okay.
The next video in this group, the petitioners are moving forward, is Exhibit 45. This is video from a speech in Wilmington, North Carolina on August 9th, 2016.
That video is also unsupported
Okay.
by the Secretary's medium.
Okay, the next video in this group again is Exhibit 46. This is a press conference where this is August 15th, 2017.
Jobs with good pay. And when they have that, you watch how race relations will be. And I'll tell you, we're spending a lot of money on the inner cities. We're fixing the inner cities. We're doing far more than anybody's done with respect to the inner cities. It's a priority for me, and it's very important.
Are you putting what you're calling the alt-left and white supremacists on the same moral plane?
I'm not putting anybody on a moral plane. What I'm saying is this. You had a group on one side and you had a group on the other, and they came at each other with clubs, and it was vicious, and it was horrible, and it was a horrible thing to watch. But there is another side. There was a group on this side, you can call them the left, or you've just called them the left, that came violently attacking the other group. So you can say what you want, but that's the way it is.
On both sides, though? You said there was hatred, there was violence on both sides.
Well, I do think there's blame. Yes, I think there's blame on both sides. You look at both sides. I think there's blame on both sides, and I have no doubt about it, and you don't have any doubt about it either. And if you reported it accurately, you would say. Excuse me, they didn't put themselves down as good. And you had some very bad people in that group. But you also had people that were very fine people on both sides. You had people in that group, excuse me, I saw the same pictures as you did. You had people in that group that were there to protest the taking down of, to them, a very, very important statue and the renaming of a park from Robert E. Lee to another name.
I apologize. I misread the year on that. This was August 15th, 2017, while Donald Trump was president, responding to the events in Charlottesville, Virginia.
Madam Secretary, could we turn up the volume just a little bit on that?
It may not be possible. Is it possible to turn up the volume for in the room? Okay. Please continue, Attorney Gaines.
Okay. The next video is Exhibit 47. This is a speech at a rally for a congressional candidate in Montana who had body slammed a reporter, for lack of a better word.
Greg is smart. And by the way, never wrestle him. You understand that? Never. Any guy that can do a body slam, he's my guy. He's my guy. I shouldn't say the truth, but there's nothing to be embarrassed about. So I was in Rome with a lot of the leaders from other countries, talking about all sorts of things. And I heard about it. And we endorsed Greg very early. But I had heard that he body slammed a reporter. And he was way up. And I said, oh, this was like the day of the election or just before. And I said, oh, this is terrible. He's going to lose the election. Then I said, well, wait a minute. I know Montana pretty well. I think it might help him. And it did.
Next, moving forward, Exhibit 48. This is May 8th, 2019. This is in Panama City, Florida at a rally. This is for the same purpose, Trump responding to a shout of a supporter in the crowd.
When you have 15,000 people marching up and you have hundreds and hundreds of people and you have 2 or 3 border security people that are brave and great, and don't forget, we don't let them, and we can't let them use weapons. We can't. Other countries do. We can't. I would never do that. But how do you stop these people? You can't. There's no... That's only in the panhandle you can get away with that statement. Only in the panhandle. I mean, when you have 15,000...
Okay, the next exhibit is Exhibit 49. This is a video from a presidential debate, Trump being asked a question about violent extremists.
You have repeatedly criticized the vice president for not specifically calling out Antifa and other left-wing extremist groups. But are you willing tonight to condemn white supremacists and militia groups and to say that they need to stand down and not add to the violence in a number of these cities, as we saw in Kenosha and as we've seen in Portland?
Sure,
are you
I'm willing
prepared
to
to specifically
do it?
Well, go ahead,
I would say almost everything I see is from the left wing, not from the right wing.
So what are you saying?
I'm willing to do anything. I want to see peace.
Then do it, sir.
Say it. Do it. Say it. Do you want to call him? What do you want to call them? Give me a name. Give me a
White
name.
supremacists and
White
right supremacists and right
Proud Boys, stand back and stand by. But I'll tell you what. Somebody's got to do something about Antifa and the left, because this is not a right-wing problem. This is a left-wing. This is a left-wing problem.
White supremacists. Antifa is an idea, not an organization.
Oh, you got it.
Not militia. That's what his FBI director said.
Well, then you know what?
No, we're done, sir. We're moving on to the next.
We're moving on to your head. That's not an idea.
Everybody in your administration tells you the truth has a bad idea.
Can I tell you what?
You have no idea.
Antifa is a dangerous,
all right,
radical
gentlemen,
group.
We're now moving on to the Trump and Biden records.
They'll overthrow you.
When a president, I'm going to ask a question.
Okay, the next the next exhibit is Exhibit 50, and this is video from October 30th, 2020, a few days before the election, of an incident involving Trump supporters with I apologize. This is video that was embedded in a tweet by Trump saying, "I love Texas." The video is showing in a stylized version an incident on a highway in Texas on October 30th, 2020.
3, 2, 1, go! Welcome to the Red Kingdom. Yeah. Red Kingdom. Welcome to the Red Kingdom. Yeah. Red Kingdom. Welcome to the place where we run it.
This tweet is embedded, or I'm sorry, this video is embedded in a tweet that also appears in a compilation of tweets that is Exhibit 37 that we're not showing one by one at this time. Let's go next to Exhibit 52. You're not going to be able to show that, are you? Okay, that was speech from Michigan. And that would be the end of that group.
Okay. Do you want to make any comments about that group and the nature of why you're presenting that as evidence? And then we'll give counsel for Mr. Trump brief comments, although you also have extensive time to brief it.
Yes, Madam Secretary. So this was a series of videos from 2016 all the way through right before the election of 2020, showing Trump on the campaign trail and in the White House, either encouraging or responding to approvingly violent incidents in his crowd or elsewhere in public events. And that is part of what we intend to show was led to the reaction and reception of post-election speeches, especially a speech given on January 6th, 2021.
Attorney Gessler, counsel has reminded me that there will be a rebuttal opportunity once evidence is presented. The objections have already been made and are going to be briefed. And so I'm actually going to permit Attorney Gaines to complete his evidence, even though that contradicts my earlier point. We want to adhere to the extent, even though this is an unorthodox hearing, we're adhering to the Maine Administrative Procedure Act. So there will be a rebuttal portion. You certainly could restate an objection if you had it at this time, but we would ask that you refrain from advanced argument, which is more appropriate in the rebuttal period.
Certainly, Your Honor. Whether it's now or later, as long as we at least have an opportunity today to sort of give you that, that's all we're asking for.
Absolutely.
Okay.
Attorney Gaines, please proceed.
Okay. Next, moving forward, this group of videos is showing a Trump questioning the integrity of elections over time leading up to the 2020 election. The first video is Exhibit 53 from a speech in Wisconsin, August 17th, 2020.
So we have to win the election. We can't play games. Get out and vote. Do those beautiful absentee ballots, or just make sure your vote gets counted. Make sure, because the only way we're going to lose this election is if the election is rigged. Remember that. It's the only way we're going to lose this election. So we have to be very careful. Now, look, this is more than this election. That's a big statement. The only way they're going to win is that way, and we can't let that happen.
Next, moving forward, Exhibit 54. This is the following week in North Carolina. This is August 24th, 2020. At the Republican National Convention.
That video is unsupported.
Okay.
Which number was it for us to? 54.
Okay. This next, moving forward, Exhibit 55. This is White House briefing on September 23rd, 2020.
Right here, Mr. President, real quickly, win, lose, or draw in this election, will you commit here today for a peaceful transferal of power after the election. And there has been rioting in Louisville. There's been rioting in many cities across this country, red and your so-called red and blue states. Will you commit to making sure that there is a peaceful transferal of power after the election?
Well, we're going to have to see what happens. You know that I've been complaining very strongly about the ballots, and the ballots are a disaster.
I understand that, but people are rioting. Do you commit to making sure that there's a peaceful transferal of power?
We want to get rid of the ballots, and you'll have a we'll have a very peaceful. There won't be a transfer, frankly. There'll be a continuation. The ballots are out of control. You know it, and you know who knows it better than anybody else? The Democrats know it better than anybody else. Go ahead.
The second question is, will you?
Please go ahead.
Next, moving forward, video. This is Exhibit 56. This is November 4th, 2020. This is the day after Election Day 2020.
United States, Donald J. Trump.
Well, thank you very much. Thank you. Thank you very much, Police said. Thank you. This is without question the latest news conference I've ever had. Thank you. Thank you. I appreciate it very much. And I want to thank the American people for their tremendous support. Millions and millions of people voted for us tonight. And a very sad group of people is trying to disenfranchise that group of people. And we won't stand for it. We will not stand for it. I want to thank the First Lady, my entire family, and Vice President Pence, Mrs. Pence, for being with us all through this. And we were getting ready for a big celebration. We were winning everything, and all of a sudden it was just called off. The results tonight have been phenomenal, and we are getting ready. I mean, literally, we were just all set to get outside and just celebrate something that was so beautiful, so good, such a vote, such a success. The citizens of this country have come out in record numbers. This is a record. There's never been anything like it.
I think that's enough. This is really the next group of videos post-election. This is Trump claiming to have won the 2020 election. That was the day after the election, Trump claiming victory in the 2020 election from the White House. Next is video. This is Exhibit 57. This is you can go ahead.
Thank you. This may be the most important speech I've ever made. I want to provide an update on our ongoing efforts to expose the tremendous voter fraud and irregularities which took place during the ridiculously long November 3rd elections. If we don't root out the fraud, the tremendous and horrible fraud that's taken place in our 2020 election, we don't have a country anymore.
This next one is going to be Exhibit 58. This is continuing on December 22nd.
The truth is, we won the election by a landslide. We won it big. It is historically, mathematically, politically, and logically impossible. It did not happen. He did not win. We won by a landslide. If this egregious fraud is not fully investigated and addressed, the 2020 election will forever be regarded as illegitimate and the most corrupt election in the history of our country.
Okay, the next video is Exhibit 59. This is response to the Trump election denial. This is Director of Elections in Georgia, Gabriel Sterling, on December 1st, 2020.
Madam Secretary, if I just may, I know we've objected. These are obviously certain characterizations or authentication of these exhibits. If we're going to go down this road with each exhibit, I think it may make sense to point it out as the exhibits come up. I mean, the exhibits stand for themselves, but we're getting testimony from counsel as to who this is and what the purpose is and what he's doing.
So are you seeking to be more specific about your objection as we go through?
My objection here is that it is counsel who is testifying as to the authenticity of this exhibit. He is saying this is who this person is, and this is what he's responding to, and this is the context of the video. That's factual testimony from counsel, as opposed to letting the video stand for itself.
Objection sustained. Counsel should be making argument as to why you're presenting the evidence, any contextual argument about why it matters for your challenge and pertains to your case, but no assertions of fact regarding what we'll let the evidence speak for itself, and you may provide context, but your statements of fact will not be accepted as testimony about fact.
It has all gone too far. All of it. Joe DeGenova today asked for Chris Krebs, a patriot who ran CISA, to be shot. A 20-something tech in Gwinnett County today has death threats and a noose put out saying he should be hung for treason because he was transferring a report on batches from an EMS to a county computer so he could read it. It has to stop. Mr. President, you have not condemned these actions or this language. Senators, you have not condemned this language or these actions. This has to stop. We need you to step up, and if you're going to take a position of leadership, show some. My boss, Secretary Raffensperger, his address is out there. They have people doing caravans around their house. They've had people come onto their property. Trisha, his wife of 40 years, is getting sexualized threats through her cell phone. It has to stop. This is elections. This is the backbone of democracy, and all of you who have not said a damn word are complicit in this. I can't begin to explain the level of anger I have right now over this. And every American, every Georgian, Republican and Democrat alike should have that same level of anger. Mr. President, it looks like you likely lost the state of Georgia. We're investigating. There's always a possibility. I get it. You have the rights to go through the courts. What you don't have the ability to do, and you need to step up and say this, is stop inspiring people to commit potential acts of violence. Someone's going to get hurt. Someone's going to get shot. Someone's going to get killed. And it's not right.
So I understand there's a request to increase the volume. Unfortunately, the volume is at max capacity for the laptop and the Zoom. Tech support has been asked to try to address that, and it is not technically possible with the technology that we have. The important thing is I can hear it, and I will be making the decision. Similarly, while opposing counsel may have some difficulty hearing, I understand that people in the room are having some difficulty hearing. They will have the opportunity over the next full 3 days to review the audio from those videos and to place any objections in their legal briefs. So it is for purposes of the hearing and the nature and the content of the hearing, the volume is acceptable. Thank you.
Okay, now we are going to move into video on January 6th. And I'll let the video speak for itself, but the intent here is generally to show the violent reaction of the crowd. There are certain timestamps on the video that we will draw attention to and let the video speak for itself, having drawn attention to the timestamp. I'm sorry. The next is going to be exhibit 65. This is from the crowd at the ellipse speech on January 6th, 2020.
Yes.
Invade the Capitol building. Take the Capitol. Take the Capitol. Take the Capitol. Take the Capitol. Take the Capitol right now.
Yes.
Peacefully and patriotically make your voices heard.
The next subset of that last set is body camera footage from Officer Daniel Hodges. Next is exhibit 67, please. And this set all has timestamps.
What are you doing? What are you guys doing?
The next is exhibit 68, same set of body camera footage. I'm sorry, 1501.
You're in a bad tackle position. You guys need to get out. You're wrong. The microphone. Hey, what can we do to help you? You guys, no, that ain't gonna happen. How can we get you out of here safely? How can we get you out of here safely? What do you gotta do? It's gonna turn bad, man. We gotta get you out of here. The others are coming up from the back.
The next is Exhibit 69.
Weapons! Take off your badges! Take off your helmets and show solidarity with we the people, or we're gonna run over you! We're gonna run over you! Do you think your little t-shirt guns are gonna stop this crowd? No! We're going into that building! Take off your badges! Take off your guns! Put down your weapons! Put down your weapons! Choose us!
The timestamp on that video was 1425. You saw a brief glimpse of the rally on the Capitol. That was Exhibit 63, and it's an over an hour long. Or the speech itself, we're not going to play that now, but it is in the record, or provisionally in the record. The next exhibit is Exhibit 70. Same group of body camera footage. The timestamp here is 14:13. And the next is Exhibit 71. The timestamp on this is 13:59.
Star Wars!
The next exhibit is Exhibit 75. Same group. Timestamp on this is 15:20. Okay, the next exhibit is Exhibit 74. I'm sorry, Exhibit 74. And if you could pull this one ahead to 1 hour and 53 minutes.
We are switching drives.
Okay. Oh,
So these exhibits were on a second drive.
I can come back to this one if I can come back to this one. I forgot. Okay, yeah, let's, because all the rest of them are on that first drive. We'll come back to this one.
Okay.
Yeah. The next one is 72, Exhibit 72.
Don't tell me that stick on me, boy. Just go home, okay? You see me, just go home. Talk to your buddies and go home. Don't tell me that stick on me. I'm not hurting you.
The next video is going to be Exhibit 73. This is no longer body camera footage, but there should be a timestamp on this. Next, we're going to go back to Exhibit 51.
I believe this will require the other drive. Is that correct? No, not yet.
This is an exhibit to the January 6th report.
My name is Marcus Childress, and I'm an investigative counsel for the Select Committee to investigate the January 6th attack on the United States Capitol.
What do you want to call them? Give me a name. Give me a
White
name.
supremacists and
What would
white
you like me to condemn?
white supremacists and white Proud
Boys, stand back and stand by.
After he made this comment, Enrique Tarrio, then chairman of the Proud Boys, said on Parler, "Standing by, sir." During our investigation, we learned that this comment during the presidential debate actually led to an increase in membership from the Proud Boys.
Would you say that Proud Boys numbers increased after the stand by comment?
Exponentially. I'd say tripled probably, with the potential for a lot more eventually.
And did you ever sell any stand back and stand by merchandise?
One of the vendors on my page actually beat me to it, but I wish I would have made a stand back, stand by shirt.
On December 19th, President Trump tweeted about the January 6th rally and told attendees, "Be there, we'll be wild." Many of the witnesses that we interviewed were inspired by the president's call and came to DC for January 6th. But the extremists, they took it a step further. They viewed this tweet as a call to arms. A day later, the Department of Justice describes how the Proud Boys created a chat called the Ministry of Self-Defense Leadership Chat. In this chat, the Proud Boys established a command structure in anticipation of coming back to DC on January 6th. The Department of Justice describes Mr. Tarrio coming into possession of a document called the 1776 Returns, which describes individuals occupying key buildings around the United States Capitol. The Oath Keepers are another group that the committee investigated.
You better get your ass to DC, folks, this Saturday.
Yeah, if you don't, there'll be no more republic. But we're not going to let that happen. It's not even an if. It's either President Trump is encouraged and bolstered, strengthened to do what he must do, or we wind up in a bloody fight. We all know that. The fight's coming.
The Oath Keepers began planning to block the peaceful transfer of power shortly after the November 3rd election. And according to the Department of Justice, Stuart Rhodes, the Oath Keepers leader, said to his followers that we were not going to get through this without a civil war. In response to the December 19th, 2020 tweet by President Trump, the Oath Keepers focused on January 6th in Washington, D.C. In response to the tweet, one member, the president of the Florida chapter, put on social media, "The president called us to the Capitol. He wants us to make it wild." The goal was for the Oath Keepers to be called to duty so that they could keep the president in power, although President Trump had just lost the election. The committee learned that the Oath Keepers set up quick reaction forces outside of the city in Virginia where they stored arms. The goal of these quick reaction forces was to be on standby just in case President Trump invoked the Insurrection Act.
Did the Oath Keepers ever provide weapons to members? I'm declining to answer that if it's grounds for due process grounds.
In footage obtained by the committee, we learned that on the night of January 5th, Enrique Tarrio and Stuart Rhodes met in a parking garage in Washington, D.C.
There's mutual respect there. I think we're fighting the same fight, and I think that's what's important.
The committee learned that the Oath Keepers went into the Capitol through the east doors in two stack formations. The DOJ alleges that one of the stacks went into the Capitol looking for Speaker Pelosi, although they never found her. As the attack was unfolding, Mr. Tarrio took credit. In documents obtained by the Department of Justice, Mr. Tarrio said in an encrypted chat, "Make no mistake, and we did this." Later on that evening, Mr. Tarrio even posted a video which seemed to resemble him in front of the Capitol with a black cape, and the title of the video was Premonition. The evidence developed by the Select Committee and the Department of Justice highlights how each group participated on the attack on the Capitol on January 6th. In fact, the investigation revealed that it was individuals associated with the Proud Boys who instigated the initial breach at the Peace Circle at 12:53 p.m. Within 10 minutes, rioters had already filled the Lower West Plaza. By 2 o'clock, rioters had reached the doors on the West and the East Plazas. And by 2:13, rioters had actually broken through the Senate wing door and got into the Capitol building. A series of breaches followed. At 2:25 p.m., rioters breached the east side doors to the Rotunda. And then right after 2:40 p.m., rioters breached the east side doors near the Ways and Means room. Once the rioters infiltrated the Capitol, they moved through the crypt, the Rotunda, the hallways leading to the House chambers, and even inside the Senate chambers.
That was our last video.
It is now permissible for you to call your witness.
Now, I was going to suggest we take a quick break and then we put on Professor Magliocca.
Council's requesting a break. Is there any objection to a quick break? All right, we'll take a 5-minute recess. And
I
return.
think Professor Magliocca has logged in, so we should be all ready to go.
We'll figure it out. Thank you. 5 minutes. We'll return here at 3:10 Eastern Time.